Good afternoon, everybody. We have a hefty docket that we want to try to get through as quickly as possible. We're going to move things around a little bit in the queue for bills. I'd like to begin with Delegate Tran and her bill. Let me pull it up here, make sure I have the right one. On collective bargaining, 1263. Delegate Tran.
Thank you so much, Mr. Chair and members of the committee. I do have a substitute from the introduced bill. It's been online this afternoon, and I had a chance to give everybody a hard copy. But if we could please move the substitute.
So moved.
Second. Moved and seconded. The substitute is before us.
The substitute, I just want to say, provides some technical clarifications about the intent of the bill, such as correcting the deadline years for implementation related matters to 2026, exempting workers' personal cell phone from FOIA disclosure, those types of things. If you're particularly interested in the handful of changes we had, I'll ask council to walk us through that. But otherwise, if you are okay, Mr. Chair, I would like to present the bill.
Yes, ma'am.
Thank you. Our public sector employees are the backbone of our communities. They teach our children, care for our seniors and people with disabilities, keep our communities safe, and deliver essential public services every single day. When these workers struggle to make ends meet, our communities feel it too. In 2020, the General Assembly took an important step by allowing local governments to authorize collective bargaining. Since then, workers across the Commonwealth have organized, contracts have been negotiated, and our civil servants in these localities have had a seat at the table. But that law left too many workers behind. State employees, home care workers, public employees in localities that refuse to recognize bargaining units still lack a voice at work. And the current system, while an improvement over where we were before, which was a total ban, created a patchwork of rules that is both confusing to our workers and our employers. Your right to have a voice at work should not depend on the zip code that you work in. This bill builds on what we started back in 2020. It establishes collective bargaining rights for public employees statewide. It includes also consumer-directed home care workers and creates a public employee relations board to ensure consistency, fairness, and clear rules for everyone. It also creates a Virginia Home Care Authority to serve as the state's bargaining representative for independent home care providers while preserving the right of individuals receiving care to direct their own care. This structure has worked in other states and helps address Virginia's growing home care workforce crisis. After local collective bargaining was enacted, Virginia moved from one of the worst states for workers to being in the middle of the pack, while remaining one of the best states for businesses. We can do both, and we can continue to do so. At a time when our federal civil servants are disrespected and disparaged, we have an opportunity to ensure that Virginia's public servants are supported and uplifted. At a time when costs are high for our families, we have an opportunity to help our working families do better. This bill gives workers a seat at the table, improves recruitment and retention, and strengthens the public services that Virginians rely on every single day. I thank you for this opportunity. I welcome your questions in the discussion today.
Are there any questions or comments from the members of the committee? All right. Anyone here to speak in favor of the bill? And before we begin, we're going to limit overall comments from both sides to 5 minutes, and we'll have a timer going. Also, let me ask folks, if you're going to be speaking, you know you're going to be speaking either for or against something, please come close. Sir.
Mr. Chair and honorable members, my name is Keith Andes, President of Richmond Professional Firefighters Association, IFF Local 995. I'm also here representing Virginia Professional Firefighters Association and over 10,000 plus professional firefighters across the state. As elected lawmakers of this great Commonwealth, you were entrusted to have a seat at this symbolic table at what you sit at today, so your voice could be the conduit in making a better life for the hardworking families that you represent. I am so very proud of the diversity of today's workforce that is represented here and across the Commonwealth, and the passion and dedication that these individuals give to their professions daily. Firefighters in my public sector sisters and brothers are worthy of the same type of representation that House Bill 1263 would afford them. For much too long, their voices have been silent. Today, we ask for our voices to be awakened and respectfully represented. By your affirmative vote this afternoon, it puts us one step closer to having this historic opportunity. Thank you, Delegate Tran, for your support, and thank you to this committee for your time today. Please stay safe.
Thank you, sir.
Hi, good afternoon, honorable delegates. My name is Daryl Turner. I am a preschool teacher here in Richmond City, a proud third-generation educator, and a proud member of the Virginia Education Association. I come before you today in support of HB 1263. A strong collective bargaining bill is essential to ensure that our public sector workers have their rights and their voices heard. Nearly 5 years ago, in Richmond, my colleagues and I of the Richmond Education Association, we waged a successful campaign to win collective bargaining rights for our school employees, the first in nearly 50 years. And since then, we've been able to make sure that not only have our voices been heard at the table to make sure that support staff had the resources that they needed, so they didn't have to choose between essential medicine or making daily groceries. So I come before you all today because we need this bill to ensure that not only we have a set of guardrails, but to make sure that our voices are heard, because with those guardrails, we will have a true seat at the table as equals to those that we sit across from. So thank you.
Thank you, sir.
Mr. Chairman, members of the committee, first I'd like to thank Delegate Tran for bringing this legislation. It's much needed in the public sector. My name is Don Baylor. I'm with the National Coalition of Public Safety Officers, representing men and women in the Department of Corrections and Juvenile Justice. I've been coming to this body since the year 1992, trying to speak for improvement in conditions and salaries for the people that work in our facilities. It seems like most of the time we've taken a step forward and 2 steps backward. Conditions never seem to get better, and in fact, they seem to deteriorate. And we've reached a point now where we're at an inflection point in public safety when it comes to corrections and juvenile justice. We have, in 2025, the second highest year on record that we experienced separations with 2,912 employees separating from the Department of Corrections alone. Reason that we see this trend is because these workers have never had a voice in the conditions under which they work. And this legislation will go a long way to change that and finally give them a seat at the table. I think then we'll be able to solve some of the problems that confront these agencies. Thank you.
Thank you, sir.
Good afternoon. My name is Angel Pye, and I'm a proud member of SEIU 512 Home Care. I'm here today to support Bill 1263. I had to leave my position as a mental health counselor to take care of my son full time. My son's name is Alexander, and he passed away last year. And in doing so, making that decision to leave my job, I provided care for him because we could not keep a home care worker because of the wages that were being paid to home care workers. So I ask you today to please support our bill because it will allow home care workers to not only have a voice, but to be able to chart their future and be independent and able to take care of themselves and take care of the people that they love.
Thank you for your testimony, ma'am. So could other folks who are here to testify, there are many of you, because we were out of time, if you could just say your name, your organization, and that you support the bill, or if you could just queue up.
Hello, yes, my name is Rosalind Anderson. I am a cafeteria manager with Richmond Public Schools. I also support the bill, and I'm also the vice president.
Thank you, ma'am.
Mr. Chairman, members of the committee, I have two. First of all, Larry Bechtel, who is the International Vice President of the Longshoremen ILA that represents 2,400 dock workers, supports collective bargaining. Now, as for me, I'm Doris Krause-Mays, president of the Virginia AFL-CIO, and workers have waited almost 80 years. Yes. We support collective bargaining.
Thank you, ma'am.
My name is Gayleen Kanoyton. I'm with the Virginia State Conference NAACP. We support support collective bargaining. It's time to get rid of the Jim Crow laws.
Thank you, ma'am.
Hi, my name is Beth Cordatis. I'm part of the Virginia United Campus Workers. I'm a term faculty, and we support the bill.
Thank you, ma'am.
Thank you.
Good afternoon. Nicholas Krakowski, duly elected to the Leesburg Town Council. I stand in solidarity with fellow Virginians for fair wages, benefits, and working conditions.
Thank you, sir.
Mr. Chair, my name is Brian Turner. I'm with the American Association of University Professors, and we support this bill.
Thank you, sir.
Judy Conti with Conti Strategies. I support the bill and thank my delegate for championing it.
Thank you.
Mr. Chairman, Brian Payton, President of Local 322 Teamsters. We support this bill.
Thank you, sir.
Carol Bauer, Virginia Education Association. We support this bill. This helps our workers, helps our communities.
Thank you.
Brian Mavosa, Teamsters Local 322, and we support this bill.
Thank you.
Mr. Chair, members of the subcommittee, Abigail Thompson on behalf of the National Public Employers Labor Relations Association. We thank the patron for hearing our suggestions, and we support the bill. Thank you.
Thank you.
Eric Judson, proud member of Local 205 Carpenters, and we all support collective bargaining.
Thank you, sir.
Patrick Brigham, IBW Local 666. We support the bill.
Thank you.
Tram Win, New Virginia Majority. We support the bill.
Thank you.
Good afternoon. Kayla Mock on behalf of the United Food and Commercial Workers Union. We support.
Thank you.
Ryan O'Toole of Freedom, Virginia. We support the bill. Thank you.
Thank you.
Hello, my name is Char Lewis with Communication Workers of America, and we support the bill.
Thank you.
Jeremy Garrett, Millwright Local 443, Council Representative, and we support the bill.
Thank you, sir.
David Broder with the SEIU Virginia State Council. We support this bill.
Thank you, sir.
Ashley Dwyer, thank you, for SEIU International, and we support this bill.
Thank you.
Mr. Chairman, David Mills with Unite Here. We support the bill.
Thank you, sir.
Mr. Chairman, Jason Asher with the Mid-Atlantic Pipe Trade. We support the bill.
Thank you.
Mr. Chairman, Thomas Killeen with Sheet Metal Workers Local Union 100, and we support this bill.
Thank you, sir.
Jason Parker, Virginia State Building Construction Trades Council. We support this hallmark of a free society. Thank you.
Thank you. All right. Anyone to speak in opposition to the bill? Once again, we have 5 minutes.
Mr. Chairman, my name is Dylan Bishop. I'm with Wilcox Savage Consulting, and I'm here on behalf of the Virginia Government Employees Association. We represent state and state-supported local employees, so the actual employees that would be affected by this bill most, and we oppose the bill. I want to be clear that we are not opposed to collective bargaining as a matter of principle, but the time simply isn't right. In Virginia, we have a constitutional mandate to carry a balanced budget. We're looking down the barrel of a $3.2 billion budget shortfall attributable to Medicaid expenses alone. Whatever limited resources we have left, we would like to go directly into our state employees' compensation and benefits adjustments instead of propping up another layer of government. The current paradigm is working. VGEA has been around for over 65 years. In the last 20, we've helped to increase wages by over 83%, and 30% of that has come since 2018 alone. The fiscal impact attributable to this is quite large, almost $90 million. And so if we are going to go forward with this, we need to take a serious look at the fiscal impact and whether the time is right. Instead, we think that there is a middle ground proposal, particularly with this bill where bargaining units would be determined based on job titles and classifications. According to a DHRM study that was just released in November, the Commonwealth has not modernized its job classifications in over 25 years. I know there's a budget amendment in the House that directs DHRM to do just that, to modernize the job classifications for $500,000 as opposed to nearly $90 million. So we think that'd be a reasonable and prudent first step. Thank you very much.
Thank you, sir.
Mr. Chairman, Bill Carrico, Virginia State Police. We represent 1,100 of the 1,800 active members of the state police, another 1,200 of support staff and retired members. We adamantly oppose the state police being in this bill. We have a dual mission to provide public safety across Virginia. We're not like municipalities. We are a statewide organization. We feel collective bargaining will slow down emergency deployment and the chain of command and complicate discipline. We did a poll amongst our members. 65% of our members said they did not support collective bargaining, and 18% only supported it. We feel like it waters down due process, and it limits our statewide ability to do the job that we're called to do. So therefore, we ask to be removed from the bill, state police be removed from the bill of collective bargaining.
Thank you, sir.
Good afternoon, Mr. Chairman and members of the committee. I am Laura with Americans for Prosperity, and we respectfully oppose this bill. This bill advances statewide mandates without first understanding the full financial impact on local government and taxpayers. The current fiscal impact analysis is very limited and does not reflect the diverse localities in Virginia, the cities, the counties, and towns. I think we only have, there was very few that turned it in. Virginia is not a one-size-fits-all, we know this. And this concern is not theoretical. I mean, just this week we had 7 mayors out of Tidewater of the major cities that signed a letter and said, you know, it's not about being for or against collective bargaining, it's keeping it in the localities. And that's 7 Republican and Democrat mayors that signed that letter and has been all over the news. For this reason, we've respectfully urged the committee to delay HB 1263 and pursue a comprehensive work study. Thank you.
Thank you.
Mr. Chairman, members of the subcommittee, my name's John Kalb, Vice President, National Right to Work Committee. On behalf of our tens of thousands of members and the 80% of Virginians who oppose forced unionism, I urge you to kill the bill. It's not fixable. But with that said, there are several elements of it that are particularly bad that I'll highlight. First, it forces governments through binding arbitration to accept costly work rules dictated by arbiters. And if you don't think that can increase your expenses, look at New York City, where the Metropolitan Transportation Authority paid $1.5 billion in overtime due to work rules which allow as much as 70 hours of overtime in a day, all bargained, and this would set up binding arbitration that takes it completely out of the governing body's hands. It would also subject workers to harassment through so-called card check elections where they're intimidated one-on-one or three-on-one into signing so-called union authorization cards. You're unionizing people without a ballot. Then there's the mandatory new hire meetings. It's a disaster for all Virginians, and I urge you to kill the bill.
Thank you, sir. Could everyone else who's speaking in opposition to the bill say your name, your organization, and your position?
Mr. Chairman and members of the committee, I'm John Jones, representing the Virginia Sheriff's Association. We oppose it. It's not a good fit for constitutional
Thank you, sir.
Mr. Chairman, I'm John Sedgwick with Virginia Professional Educators. We oppose the bill. We're concerned about the abolition of the secret ballot in elections and also the creation of the PERB.
Thank you, sir.
Thank you.
Mr. Chairman, members of the subcommittee, Sophia Pineda with the Virginia School Boards Association, and we also oppose this bill. Thank you.
Thank you, sir.
And Mr. Chairman, members of the committee, Mark Flynn on behalf of VML and VACO, just for the cost issues, not the fairness, we oppose the bill. Thank you.
Thank you, sir.
Good afternoon, sir. Laura Novi with the Virginia Association of School Superintendents, and we would like to keep the local option law, which is currently in place. Thank you.
Thank you, ma'am. All right, I think we have someone online to speak in favor of the bill. 2 individuals speak in favor of the bill, and one in opposition. Ms. Yen.
Hi, I'm Dr. Emily Yen, here on behalf of Teamsters 322. We support the bill. We believe especially that we need a public employee review board, and hope that you support this bill. Thank you.
Thank you. Thank you very much. Mr. Gibson. Mr. Gibson has frozen. Mr. Gibson has disappeared. Ms. Brescia.
Yes, hi. My name is Sarah Brescia, or Brescia, that's actually the correct way to say it. I am a Manassas City School Board member. I'm speaking on my individual capacity, to be clear on that. I'm a mom of 3 and a former member of the United Federation of Teachers as a former New York City public schools educator. And I urge you to modify this bill. I'm particularly concerned about the binding arbitration and the fact that there are only 3 states in the whole United States that have collective bargaining in public schools, but do not let their school boards levy their own taxes. And that is us, Maryland, and West Virginia. Maryland, it goes well in Montgomery County where people are wealthy, but it does not go so well in Baltimore City. And here in Manassas City, which is a working class city, it would be a very difficult process to implement. So I urge you, you have the time to take the time and modify the bill. I'm also concerned about binding arbitration and the creating of an administrators union. If your task is to turn around low performing schools, having an administrators union and extremely rigid systems is going to make that very difficult. Thank you for your time.
Thank you, ma'am. Mr. Gibson.
Hi, yeah, I'm back. Can you hear me? My name is Tim Gibson. I'm the president of the Virginia Conference of the American Association of University Professors. On behalf of our members who teach and conduct research in public universities and colleges across the Commonwealth, I want to express our strong and enthusiastic support for collective bargaining rights and HB 1263. I'm here with a simple message. Extending collective bargaining rights to public employees is the single most important step you can take to advance the teaching and research missions of Virginia's public colleges and universities. With collective bargaining rights, Virginia's professors will have a stronger voice to advocate for better learning conditions for our students and better working conditions for our most vulnerable instructors. Collective bargaining also means that professors can work collectively to protect the values at the heart of the university, including academic freedom, open and free inquiry, and freedom from external political pressure. This is a slam dunk. Thank you, Delegate Tran, for introducing this bill, and it has our full support.
Thank you very much, sir. Any questions or comments from members of the committee? Delegate Runyon.
Delegate Ballard, actually.
Delegate Ballard first. I apologize.
Oh, no, you're fine, Mr. Chair. Mr. Chairman, thank you. Just briefly speaking to the bill, I mean, I share many, if not all, of the concerns that the individuals spoke in opposition, but I just want to highlight the fiscal impact on this. When you look at the FIS, you're talking about FY27 through FY31. It looks like an average of about $55 million from the general fund, and then the non-general fund in the first year, almost $30 million, and then it ticks down to just over $20 million. I mean, that's a significant hit on the general and non-general fund. If you look further in that analysis, I mean, we have to create 300 new positions just to address some of this stuff, and that comes at a cost, salary and benefits of $38 million, $17 million to the general fund, $21 million to the non-general fund. And so, obviously, I know where this is going, and certainly no one on our side can slow this train down, but I would like everyone to just kind of pause for a second and understand the extreme fiscal impact to our budget. Thank you, Mr. Chairman.
Delegate LeVar Bowling.
Thank you, Mr. Chair. I just had a comment.
What was that?
I had a comment.
Yes, ma'am.
Thank you. I wanted to really speak to the crux of the bill. First of all, I wanted to thank the patron for bringing forth such an important piece of legislation. And I also wanted to talk about the importance of the freedom to be able to form a union and bargain collectively for a contract. It's a freedom that I think personally should lie with workers, and it shouldn't lie with their employers. It shouldn't lie with politicians, and that is what your bill does. It allows the decision to be put in the hands of workers, which is where it belongs. Secondly, I think it's important to make clear that this bill is about affordability. Plain and simple. Things are tough right now, and from testimony here today, we see that from our firefighters, our teachers, our campus workers, our home care workers, our corrections officers, and all of our other public service workers deserve the chance to come to the table and negotiate for their salary, their families, allow them to support them. You know, the folks who are teaching our children, who are running into burning buildings to save our lives, the people who keep our universities clean and who care for our seniors and for the people with and who care for our seniors and people with disabilities. They all make our communities better, and they deserve to be able to live and not just skate by day after day, paycheck to paycheck. And the other portion that I think is really important to highlight about the bill and about the topic of collective bargaining is that the bill is rooted in Virginia's Jim Crow history and trying to eradicate that. The Virginia General Assembly passed a joint resolution prohibiting the state from recognizing public sector unions after Black nurses at the University of Virginia tried to organize, right? And we are here in 2026 and we have to right that wrong. The bill is not just about economic justice, but it's also about racial justice. And so it's past time that we pass the bill. So I do want to thank you for your courage and your passion in standing up for workers across the Commonwealth. And Mr. Chair, when it is appropriate, I do have a motion.
Thank you, Delegate LeVar Bowling. Delegate Runyon.
Thank you, Mr. Chair. A question of the patron, please,
Yes.
Mr. Chair. So, Madam Chair,
Delegate Runyon.
Thank you, Mr. Chair. Delegate Shin, I do want to associate my comments.
Tran.
I'm sorry. I apologize. So, So, Delegate Tran.
I know I threw you off.
Beg your pardon?
I said I threw you off a little bit.
Yeah, I'm sorry. I do want to associate my comments, or myself, with the comments the Delegate Ballard made about the physical responsibility. It is quite eye-opening when we look at that. But I've had a number of folks come to me and suggest that we've got some challenges with the collective bargaining application to constitutional officers and the offices and the state police. Did you have discussions with those groups and see, can you share with us what was attempted to be done to maybe carve those out? I share the concerns of how a constitutional office may be able to apply this, and then I think the state police have a reasonable point of view on the challenges that this bill is going to add. And again, I apologize.
Yes, Mr. Chair, if I could respond to the Delegate Runyon.
Yes, Delegate Runyon.
I did meet and hear from both state police, represented by Mr. Carrico, as well as the PBA. And the PBA does support the direction that we're moving in. So I want you to know, I think there's some division within that community. Mr. Carrico told me overall that he would oppose this bill, but if it does move forward to make sure that state police are pulled out in their own separate bargaining unit, which you will see I have incorporated on line 511 to try to address that concern that state police are a little bit different than other law enforcement that we hire that are public servants, right, at the state or local level. So we did try to address that concern. I think fundamentally with the around the constitutional officers, what the Senate has done, and I think we will make when we get over into the Senate and into conference, is just to clarify that our constitutional officers will have it'll be optional for them. But I do overall just want to say that just because you have a right to collectively bargain doesn't mean that suddenly the door is going to have this influx of all the workers bargaining and forming a union. And maybe that's what those who are opposed to fear, right? Because the current paradigm is not working. But workers still have to elect to join a union. There has to be, as part of that process, an election. Then they, in their bargaining units, they will then negotiate, right? So it is a process. It is not. So I just want to clarify that it is a process, it is a discussion, it is having a voice in that communication.
Delegate Runyon, is that all right? Yes, thank you. Any more questions or comments? Delegate Ward.
Yes, Mr. Chair, thank you so much, and thank you so much, Delegate also Tran, for speaking with us today. There's just a couple of things I want to say. When you talk about collective bargaining, everybody, the first thing they think about is money. What is it going to cost us? What we're doing is talking to each other. Right. That's what we're doing. We're talking about talking. In my day job, I am the president of a teachers union. And most of the time what I hear when people want to leave, it's like, we don't care. We're not talking about money. Nobody listens to us. They want to know that their administrators are listening to them. That's why before school starts, you have all these ads looking for more teachers, and you keep paying them more, And what they want is to be heard. School bus drivers, we're looking for school bus drivers. All they want to do is be heard, just like you today. All of the advocates, all of the lobbyists, they come to talk to us. They want to be heard. That's what collective bargaining is first. First thing everybody talks about is how much money it's going to cost. And the first thing you got to do is listen to what people need. And that's why collective bargaining is a good thing, because it opens communication. That's the main thing. Thank you, Mr. Chair.
Thank you, Uber Chair. So the committee works by motion.
Mr. Chair,
Delegate Lira Bowling.
I'd like to move to report and refer this bill to appropriations.
Second.
So yes, this bill does have a letter. It will have to go to appropriations. It's been moved and seconded to report and refer this bill to appropriations. Oh, with the substitute, as substituted. All right, let's go to the big board. Excellent. By a vote of 4-2, this bill is reported and referred with substitute to appropriations. Thank you very much,
Thank you, members of the committee.
So because we have so many other committees going on, and one of the chairs of those committees is here, we're going to have Delegate Simon come forward. But before we do that, let's, because of there's a couple things we need to do in terms of rolling in legislation into his bill. Can we have a motion to carry over or to roll Delegate Delaney's Bill 1216 into HB 930?
So moved.
Second, all those in favor say aye.
Aye.
All right, so we've accomplished that goal. And then we also want to roll in Delegate Leftwich's Bill 722 into HB 930 as well.
So moved.
Moved and seconded, all those in favor say aye.
Aye.
All right, so we've dispatched those two bills, and they are now before us. Delegate Simon, do you have any amendments or substitutes to your bill?
Mr. Chair, I believe there is a substitute that Council's distributed on this bill.
All right, substitute. Do we have a motion to accept the substitute? Moved and seconded. All those in favor say aye. Aye. All those opposed? Substitutes before us. Delegate Simon.
Thank you, Mr. Chairman, members of the subcommittee. This bill helps build on the work that we did a few years ago, about 5 years ago, as far as whistleblower protection for employees in the Commonwealth of Virginia. HB 930 strengthens and expands existing law by adding clear, explicit language which will allow for employees to come forward in good faith to report unlawful actions. The substitute expands protections to employees who report violations to a manager, officer, or other employee, in addition to a supervisor or law enforcement. There's a lot of times that whistleblower, the discussion, they don't know who to go to, so they sometimes go to a colleague, sometimes an immediate supervisor, but sometimes they won't. And so this just sort of broadens who they can whistleblow to and still receive protection. It also prohibits employers from using handbooks, contracts, other agreements, or gag orders to silence employees, so they can't contract around these whistleblower protections in their employee handbook or employer contracts. It allows the commissioner or attorney general to bring forth civil action. So sometimes somebody's a discharged employee doesn't have the wherewithal to bring the suit themselves. So this would allow the attorney general to bring a suit on behalf of people whose rights have been violated. It also ensures workers who face retaliation are fully protected by law and courts to provide any sort of variety of equitable remedies. It does require, and I know the chamber's got some concerns about this bill, changing the language from may to shall. It does say the court shall order a remedy, but it says such legal or equitable relief as may be appropriate to effectuate the purposes of the section. So the court still has a lot of discretion and latitude. What they can't do is just say, we're not going to give any remedy here. Yes, you violated the act, but no, we're not going to do anything about it. I know that different reading by different attorneys, but I think that's fairly clear that it preserves the discretion of the court and the finders of fact. Finally, again, it just broadens the coverage of protections across various workplace environments and allows employees the opportunity to come forward and report illegal conduct. I think it's important to all Virginians, if an employee knows something's going on, something fishy is going on, they shouldn't have to choose between keeping their job and letting the world know that the law is being violated. I think this bill strikes the appropriate balance and builds on what we started to do 5 years ago.
Thank you, Delegate Simon. Any questions or comments from members of the committee? Delegate Ballard.
Thank you, Mr. Chairman. Question for Delegate Simon, and I know you have to go, but so when I read this, I thought it kind of deals with at-will employment. Like when people come in my office with, employment cases, I start with the premise that, hey, Virginia has at-will employment. So when I read this, either you can address or would you agree with me that this kind of would eliminate the concept of at-will employment in Virginia?
No, I would disagree with that. It's still at-will employment, which you can still fire somebody. You just have to show that you would have fired them, and you have a clear and convincing evidence standard. You would have fired them anyway, whether or not they've been a whistleblower or not. So you can't fire somebody exclusively for being a whistleblower, but if you can show that you had another reason and you would have fired them anyway and demonstrate by clear and convincing evidence, you don't have to give any other reason to show that it wasn't because they were solely because they were a whistleblower.
Brief follow-up, Mr. Chairman.
Delegate Ballard.
So correct me if I'm wrong. I mean, we already have a Whistleblower Protection Act in Virginia, right? And this changes that? Does it address it?
So this, again, it just broadens some of the protections. It adds certain practices that weren't covered, some of the ways that folks were really evading it, by, again, trying to contract it around or saying, hey, you put in your employee handbook, discussing illegal activity of the company is a fireable offense. Right now, you've essentially defeated the purpose of the whistleblower protection. So we want to add some protections for things like that. It's sort of building what we've already got.
Thank you, Delegate Ballard. Any other questions or comments, members of the committee? All right, with that, is there anyone here to speak in favor of the bill? Once again, if you're going to speak in favor, please come close before we call you.
Judith Conti here on behalf of the Virginia Employment Lawyers Association and the Metropolitan Washington Employment Association. Thank you, Mr. Chair and members, and Delegate Simon for championing this important bill. We believe that it is time to improve the steps that Virginia has already taken to protect whistleblowers and finish the job. This will strengthen whistleblower protections, give people protections against retaliation when they bring good faith claims of illegal conduct forward. It will broaden the reporting channels so that they can report to supervisors, managers, a government body, and it can happen in the ordinary course of employment. Finally, we would say that this is also something that will benefit Virginia employers, because if there's an effective whistleblower protection statute, it will increase the likelihood that employees will report unlawful conduct internally that an employer may not be fully aware of because of misconduct going on. Therefore, it gives them an opportunity to correct the illegal conduct and take remedial action before it becomes more serious. Finally, I would just note that in the judicially created doctrine of wrongful termination in the state of Virginia, addressing Delegate Ballard's question, there already is an exception to employment at will when employees are retaliated against for whistleblower protections and are fired because they refuse to take illegal actions. So this is in complete harmony with the exceptions to the employment at will doctrine in the Commonwealth already. Thank you for your attention to this.
Thank you, ma'am. Anyone to speak in opposition to the bill?
Good afternoon, Mr. Chair, members. Ethan Betterton with Virginia Chamber of Commerce. Disagree strongly with the previous statement as far as this being beneficial to employers. We believe that this legislation, as amended, quickly looking at the substitute, would make everyday workplace management legally unworkable. Virginia already has one of the broadest whistleblower protection laws in the country, and this bill goes much, much further than any other state. And I would just like to highlight a few examples of how unworkable this is. So this is line references to the original bill as introduced, but I retained in the substitute lines 22 to 25, incorporating or other employee. We interpret that to mean any offhand remark to a coworker carries the same legal weight as a formal report to HR. An employee could complain to a coworker, "This isn't right," without specifying anything as far as specific legal or regulatory violations, be later disciplined for attendance issues, and then claim retaliation based solely on that comment. As far as the legal standards set on the employer, we think that's pretty unworkable, and the remedies are rather extreme. So just as an example, a small business could terminate an employee for repeated, well-documented misconduct, but if the employee complained just once, and again, not even necessarily to a supervisor, reinstatement is required if the employee is prepared. Actually, I think that's out of the substitute, so that might be an improvement in that regard. Nevertheless, the concerns remain as far as this being really unprecedented in law. On the point about the handbooks and the ability to elevate concerns through HR, disagree strongly with that statement. I think that this bill will encourage more litigation rather than resolving complaints internally. We really urge you to oppose this bill and believe that if this legislation passes into law, the business and legal climates, the impact on the business and legal climates of the Commonwealth would be devastating, and do share the concern expressed by Delegate Ballard that this really does get at will employment, notwithstanding the appropriate protections already existing in law. So thank you for your consideration.
Thank you, sir.
Mr. Chairman, members of the subcommittee, Jody Roth on behalf of Virginia Retail Federation. We strongly oppose this legislation based on the reasons that Ethan with the chamber just stated, but also wanted to highlight on line 14 adds former employee, which means if an employee sues the employer, cannot file a counterclaim without being liable for retaliation. The employer should have the right to sue for fraud and defend themselves as an employee. And also on line 41 through 42, the language creates, which was already mentioned, but I wanted to highlight again, that handbooks would be on trial for any possible argument that provision somehow restricts employee complaints, effectively requiring all employees to rewrite their policies and their handbooks to avoid litigation risk. Those are just a couple that I wanted to reiterate again, and thank you.
Thank you, ma'am.
Mr. Chairman, members of the subcommittee, Travis Smiley with the Virginia Food Industry Association. In addition to what Ethan and Jody have already spelled out, I'd like to point you to Section F of the substitute, particularly the phrase term or condition. We believe that could be read broadly to mean a claim is not releasable in a settlement or severance agreement. In other words, an employee could settle a case or receive a severance and sign a release only to then bring a whistleblower claim by saying it cannot be released from agreement, which we believe would be wholly unprecedented in law. So for those reasons, we strongly oppose. Thank you.
Thank you, sir. Anyone online? All right. Any more comments or questions from members of the committee? All right. With that, the committee works by motion.
Second.
Moved and seconded to report the bill. This does not have a letter. All right. Let's go to the big board. Oh, sorry. Motion is to, can we redo that motion?
Move to report with substitute.
Move to report with substitute. Second. Moved and seconded. All those in favor say aye. Well, let's go to the board. There we go. Can we destroy the roll and do that again?
There it is. This is report with substitute.
So we've moved and seconded the motion to report with substitute.
Yes, sir.
All right, let's go to the board.
I've got it forwarded to.
Yeah, let's do it again. Destroy the roll.
Destroy.
Yeah. We good?
Yes, sir. There.
All right.
Thank you, Mr. Chairman, members of the subcommittee.
All right, by a vote of 4-2, the bill is reported with substitute. Thank you very much, Delegate Simon.
And the folks waiting to testify in the housing sub, thank you as well for.
All right, thank you. All right, with this, there's one more bill in another subcommittee. I'm going to hand over the gavel to Delegates Converse Fowler, and the next individual on the docket is Delegate Herring.
Delegate Herring, HB 398.
Great. Thank you, Madam Chair. Madam Chair, I do have a line amendment. I don't know if.
Do we have does council want to report the amendment? Or?
Yes, Madam Chair, Delegate Herring, the amendment on line 272 after the sentence that ends in claim, insert, in the event that an award of benefits is reversed, such person shall refund any compensation collected from the veteran, except that this requirement shall not apply to decisions to lower benefits based on improving functionality. And after fee at the end of that line. Does this not sound right?
I did not know it went that. I only familiar with the first part. So if you could repeat that.
No problem. It's inserting a sentence before the last sentence on line 272. And the sentence that I have prepared is that in the event that an award of benefits is reversed, such person shall refund any compensation collected from the veteran, except that this requirement shall not apply to decisions to lower benefits based on improving functionality. Does that sound
Yes, that's fine. Thank you.
Do I have a motion on the amendment? All right, all those in favor? Aye. All right, any opposed? All right, the amendment's before us. Delegate Herring.
Thank you, Madam Chair. This bill is Safeguarding American Veterans Empowerment Act. This bill ensures that Virginia's veterans trying to access benefits are protected from predatory practices while maintaining their freedom to choose how they navigate the Virginia disability process. Despite the existence that we have the Veterans Service Organization and taxpayer-funded state support, thousands of veterans choose to seek private, paid expert help when navigating their disability claims process. This is often because they want specialized attention or a different level of service. For many, the VA disability process is hard, adversarial, and fundamentally broken. Even the best state-run systems are frequently overworked and under-resourced. Filing for disability should be no different than filing for taxes. Veterans should have the right to do it themselves, use a free service, or hire experts to help them. Most of the private companies that offer the services are veteran-owned and operated. The choice to use the services is a right that should be preserved and protected, not eliminated. Like any industry, there are good actors and bad actors, and the answer isn't to shut down the entire industry, but instead have some consumer protections in place. Virginia currently lacks any protections or adequate protections tailored to veterans. This bill will fill that gap, ensuring that legitimate veteran-owned businesses can thrive while bad actors are rooted out. And Madam Chair, you'll see and committee members, you'll see in the body of the bill and the protections that were built in. Specifically, I would like to point your attentions to line 262 through to go all the way down to 299. And then, of course, we have more because there are penalties. So there are disclosure requirements. There are requirements that, no one can get, the services cannot receive compensation until there is recovery. And there are limits on the compensation received.
Thank you, Delegate Herring. Do we have any questions from members of the committee? Delegate Ballard.
Thank you, Madam Chair. Leader Herring. So, I struggle with this issue, to be quite candid with you. Yes. So I have a few questions.
Sure.
If I understand it correctly, there really are no limits on how these claims sharks operate without this law. Is that a fair statement?
And as I will, yes, there are people, I think there are bad actors out there. There are companies who are legit, but yes, there is no limit. There's nothing to prevent someone for requiring a fee up front or a limit on recovery. And this will put a hold on that so they're not recovering an exorbitant amount of money.
Do you have a follow-up,
Yes.
Dr. Ballard?
Yes, ma'am. Follow-up, Madam Chair. Maybe a couple questions if you would allow me.
Sure.
And so if I'm clear, your bill doesn't require any veteran seeking benefits to use any of these services. They can still utilize the free services from our veteran service organizations.
That's absolutely correct.
Follow-up, Madam Chair?
Yes.
And if I understand your bill correctly, to go one step farther, your bill does not limit in any way the ability of veterans to utilize the free services. It doesn't put any guardrails or parameters or prohibitions or mandates on how a veteran would utilize the free services from the Veteran Service Organizations.
Madam Chair, to answer the delegate, yes, absolutely. You're correct.
Okay. Thank you, Madam Chair. Those are all the questions I have for now.
Right.
Appreciate it.
Thank you.
Thank you, Delegate Ballard. All right, let's have those in favor of the bill. If you're here to speak in favor of the bill, please come up. And if you're in opposition, please get ready and come down. All right, thank you. Go ahead.
Madam Chair, members of the committee, thank you for allowing me to provide testimony today. My name is Mark Christensen, 25-year Army vet and Chief of Staff at Veterans Guardian. We're a veteran-owned and operated company with over 200 employees who primarily employ veterans, spouse of active duty service members. We're helping veterans across the world, and here in Virginia, we've helped nearly 7,500 veterans and have another 3,600 active cases right now. We've helped bring in an additional $84 million worth of benefits to Virginia veterans every year that they wouldn't have otherwise obtained. That number will continue to grow as we help more veterans in the state. We appreciate the approach of legislating guardrails against specific actions while maintaining freedom of choice and options for veterans while they navigate this difficult process. And we should strive to put those guardrails in and provide the broadest array of options while we stop predatory practices and don't limit those options that a veteran would otherwise have. We believe that there should be restrictions in our industry and that we should be addressing predatory practices, and that's why we support this bill. I'm coming to you as a representative of the industry, asking you to regulate us with common sense consumer protections. We thank this body and the delegate for bringing this and for its tremendous work and effort over the last 2 years to arrive at this particular point. These guardrails will stop predatory practices while still meeting veterans' freedom of choice, and we appreciate that. Thank you for the time today.
Thank you so much. Come on up. Welcome.
Madam Chair, distinguished members of this body, my name is Brian Payton. I'm speaking to you today as the son of a Vietnam vet, and I know what my father went through trying to secure his benefits, having to learn how to navigate the system, all the pitfalls, all the obstacles, and if it wasn't for having people that knew how to navigate the system, kind of sharing that information with him, he possibly could have fallen victim to some of these predatory actions. My issue here is really, you take people that give the United States of America a blank check up to and including their life as they go out here and service this country, as they go out here and fight and defend this country and its citizens. And then they come back, and in the process of returning from service, sometimes they experience physical, mental, and emotional harm, if you will. So the person that would seek to exploit that and to leverage that and use that as a means of conning people out of money, for lack of a better term, we need to do better. We need to make sure that our veterans receive what they earned, what they fought and suffered for when they return. And this bill right here accomplishes just that. Thank you very much.
Thank you. Anyone else here in support?
Yes, good afternoon, lady and gentlemen members of the committee. B. Gonzalez, my client, could not be here, but we represent Veterans Benefit Guide, which is a veteran-owned service in the space. We have helped over 4,900 Virginians work on their disability claims. Veteran-owned, the leadership team has won all sorts of service awards and medals, and they take pride in helping veterans. More often than not, we are seeing folks that have gone to the VFW and gone to VSOs and have been frustrated by the process. We have a wait list of veterans who want to use our services. So we think that all those services give more options to our veterans to get their disability claims. And so what we do is we help them put together their packets of information. We go through their medical records and help them prepare a better submission to the VA. So we want veterans to have better choices and more options. VFW and VSOs do a great job. They do a great job. They're the first places that most people go, and we don't work with folks that have not done that first. And so I want you to know that this bill really puts parameters and guidelines on the services that we provide, and we are really supportive and thankful that Leader Herring has brought this bill back and added some more consumer protections. Thank you.
Thank you.
Madam Chair, members of the subcommittee, Dana Wiggins with the Virginia Poverty Law Center. As we did last year, we thank the delegate for the bill. As part of the broader legal aid community, there are just not enough legal services available for all the people who need them, particularly for veterans, and we want and appreciate having consumer protections to make sure that they have access to services that they really do need. These processes can be long and arduous for them to do on their own, and we appreciate all of the different options that people have, particularly veterans. There's more options are better so that they have access to the benefits they deserve. Thank you.
Thank you. All right. Anybody in opposition of the bill? Let's go ahead and reset the time. Welcome.
Madam Chairman, members of the subcommittee, thank you for the opportunity to speak. My name is Ron Riffle, and I serve as the post commander for VFW Post 4009 at Norfolk. As the Department of Virginia Veteran VFW Legislative Chair, I'm here on behalf of VFW Department Chairman Doug Hoffman. He sends his regrets that he had to be at work today and was unable to testify in person. He may be online, though, checking what I'm doing. The VFW is active in Virginia with 120 posts and 32,163 veterans that are members across the Commonwealth. Virginia's veterans and veterans of foreign wars respectfully urge you to vote no on House Bill 398. Do not feed the claim sharks. House Bill 398, the Safeguarding American Veteran Empowerment Act, is presented as a bill to protect veterans from predatory actors. But according to the bill's summary and provisions, 398 would authorize and regulate compensated claim services rather than prohibit them. Let me be clear, this bill legalizes the very business model that keeps claim sharks that they feed on. Under 398, uncertified individuals are allowed to charge veterans for assistance with veterans benefit claims. The bill permits fees that can reach up to 5 times the monthly benefit increase, which could be up to $20,000 out of a veteran and their family's pocket. It also allows charges even in the first year if the veteran is willing to sign a waiver of his benefits. This fundamentally undermines the long-standing federal premise that filing a VA, Veterans Administration, claim should always be free. HB 398 also creates a state-level regulatory structure for anyone who wants to help veterans prepare or submit claims, even if they are not accredited by the United States Department of Veteran Affairs. The federal accreditation system exists for this reason, to ensure competence, accountability, and ethical standards. And as a side note, that oversight is going to require funding, and that's not addressed here. So that may be a piece for you to consider. HB 398 sidesteps this by allowing uncredited individuals to legally provide those services for a fee if they follow the paperwork requirements in this bill. This is just sneaky. This is an extremely dangerous for veteran bill. Unaccredited preparers are not recognized by the Veterans Administration, and they cannot represent a veteran. This bill authorizes that. They are not held responsible if they provide incorrect, misleading, or incomplete advice. Veterans end up carrying all the legal and financial risk, while the preparer walks away with their money. This is the very pattern of abuse that we see today from our national claim shark companies. Claim sharks are among us. Veteran Guardian testified earlier that they serve 1,500, 1,700, whatever the number of veterans here in the Commonwealth, and they brag that they've leveraged, I thought it was $48 million at the Senate meeting. Today it's $84 million, but they didn't talk about how much they charge those veterans. Veteran Guardian are also fighting a class action lawsuit in North Carolina by not properly serving our fellow veterans in the Tar Heel State. They also have been presented a cease and desist letter from the Veterans Administration not to serve our veterans unless they are certified claims reps, trained and monitored by the VA. Why would they not want to follow these federal laws and best practices the VA expects to protect our veterans and their families, but yet they endorse passage of 398 today? Meanwhile, accredited VSOs and the Virginia Department of Veteran Services provide expert, properly trained, and free assistance. Why now? They would now have to compete with paid bad actors, unregulated bad actors. This dilutes the integrity of our entire claim system, the process, and invites the same predatory companies that have harmed veterans across the country to expand into our state. I ask that the Senate, what do we mean to be compete for veterans? I was asked in the Senate, what do it mean to be competing for veterans? The VFW does not do claims. We have relied on the Department of Veteran Services to do claims, so that information is incorrect. We also rely on other VSOs that are doing that work, but they're all accredited. And that's the big hang-up with the VA. And those folks are also responsible for actions. Thank you for your time.
Thank you so much. All right, do we have anyone online? one online. All right, can we bring them in?
Good afternoon. I'm Danielle Hall. I am in support of the bill. Actually, I missed my my time to speak and support, I guess, before you guys moved into those who are opposed. I am a disabled veteran myself of the United States Air Force. I am also the daughter of a disabled veteran of the United States Air Force and the proud mom of two young men who proudly carried the military service legacy on in my family. And one of those two sons is also a disabled veteran. Probably the most compelling story out of all of our struggles with the Veterans Administration to get the benefits that we were entitled to after we served our country was my father, who was a Vietnam veteran. He retired from 26 years of active duty, came out with a disability rating of about 80%, and went on to become 100% unemployable. It wasn't until the last year of his life, when he was suffering from all of the cancers associated with his exposure to Agent Orange, that we really came to understand exactly how much 100% disability meant. And during that time, we went to one of the free services, had a VSO, processed my dad's claim for an increase in his benefit, and it was denied. My father had a very complex issue with his claim that really needed somebody who had more extensive expertise to be able to get his claim processed. At that point in time, we had to then enter into the appeals process, which took substantially longer. And we were able to get someone who could walk his paperwork through. And even though we were able to see some expeditious measures, my father died without his dignity at the hands of a broken VA system, and he was awarded his 100% disability 3 days after he died. The critical difference to my family would have been aid and attendance had he have been awarded in time. That would have allowed my father to have had someone come in and bathe him and feed him, so that his daughter, myself, would not have to humiliate him, excuse me, by being there and doing those things that would have allowed him to have had his dignity. I am in support of the regulatory guidelines that these measures put in place that prohibits the predatory practices of the bad actors. We do recognize that they're out there, but veterans deserve to have a choice in time where time is of the essence, so that we can exercise our choice in being able to facilitate an expeditious processing time, that these companies are seeing significant results in areas where you can't access a VSO in a timely fashion. And so I want to urge you to support this measure. I am in support of this bill, and thank the crafter of this bill for the thoughtful consideration for veterans like my family. Thank you very much for hearing me today.
Thank you, Ms. Hall. So we've heard from supporters from the opposition. I apologize, ma'am, we ran out of time for both. And so are there any more questions or comments from members of the committee? Delegate Ballard.
Thank you, Mr. Chairman. Maybe Leader Herring can answer this, because it was something that the gentleman from the VFW raised. And I mean, this concern, I want to make sure we get this right.
Sure.
I'm a lifetime member of the VFW. I want to make sure we're doing the right thing here. And I don't want to put words in his mouth, but I think he said something about they are not accredited, like Veterans Guardian or whoever he was talking about. They're not accredited. If I understand it correctly, they cannot ever become accredited, because like they're not attorneys, they're not agents, and so like even if we would mandate it, they can't get accredited. Is that, am I understanding it correctly?
That is correct. There's no pathway for accreditation. But if I may add, Mr. Chair, the problem that we're running and veterans are running into is a backlog, and if you will allow me, if the clerk can hand out an example from the veterans website, Mr. Chair, is that if he's allowed to hand that out, veterans are faced with not accepting claims now from those who are trying to provide services. And so either they go to the ones that are available and sit and wait. And so that's why individuals are trying to help. And as you'll see in the bill, there's no access, they cannot have access to their file, et cetera. They just provide them assistance. And my concern is that we do nothing. It's going to continue without any guardrails. And this did pass the Senate 3-4 with by overwhelming bipartisan support. So,
yes. Thank you. Any more questions or comments from the members of the committee?
Mr. Chair, I just want to speak at the appropriate time.
Delegate Ballard.
Thank you, Mr. Chairman. And I wouldn't normally do this, but again, I think it's super important. I mean, I've gotten a lot of emails from the VFW, from other folks in support and opposition. And so I will say this, not to brag or boast me. I've been in the military 21 years. Lifetime member of the VFW, lifetime member of the Night Stalkers Association. My first deployment was to Afghanistan. I think I was there 3 weeks. A member of our unit was killed, and he ultimately got the Medal of Honor, Jared Monty, June 21st, 2006. Second deployment to Iraq. Spent a year in Iraq. Suicides, injuries, death, destruction, you know, the worst things in the world. So I want to make sure these folks are taken care of. My third and fourth deployment with the Joint Task Force when I was with the 160th Special Operations Aviation Regiment. If you know anything about that unit and those pilots, they crash helicopters all the time. And it's probably some of the worst injuries you will see. And I had one guy come in my office, and he was talking about how he had crashed a helicopter 6 times, because if you haven't crashed it, you're not flying it right. That's why they're the best pilots in the world. So I deployed twice with the Joint Task Force. I'm airborne qualified, air assault qualified, Pathfinder qualified. I've been to SEER school. I've done a lot of things in the Army. Seen a lot of things that probably at some point I'll file for disability, and I'll probably use one of these services. So I say all of those things not to brag, but I would never do anything ever to hurt our veterans, ever. And so I think this is a good bill. I think it puts guardrails. I think it gives our veterans options. And so I appreciate you doing this, and I support it wholeheartedly. Thank you.
Thank you.
Any more questions or comments? I would also say, Delegate Herring, that I come from a family of veterans, and we would do nothing to harm or do anything that might jeopardize the well-being of veterans. At that being said, I think that there are some questions about what's next. And actually, hold on for 1 second. If we can go at ease for a moment. Back from ease. Just to remind everybody that if this passes, it needs to go to appropriations. We just got a letter. And so with that, the committee works by motion.
Move to report and refer to appropriations with amendments.
It's been moved and seconded that the bill be if reported and referred to appropriations with amendments. Let's go to the big board. All right. By a vote of 6-0, the bill is reported and referred with amendments to appropriations.
Thank you, Mr. Chair, and thank you, committee members. I appreciate you.
Thank you very much. We apologize about the delays and things, people going back and forth for subcommittees and other committees that they have to attend to. We're going to have Delegate Maldonado go next because she's been so kind to wait, and then Delegate Karen Keys-Gamarra. And then we'll have Delegate Reed and then Delegate Benita Anthony go. With that, I'm going to hand over the gavel once again to Delegate Converse-Fowler. Thank you very much.
Thank you, Mr. Chair. Thank you, Madam Chair, members of the committee. There is an amendment.
All right. Can the clerk report the amendment? Or can
Oh, sorry. Yes, I'm sorry. We'll do HB 636. I forgot I have several.
HB 636?
636. Yes,
HB
Madam Chair.
636. And do we have an amendment?
There's a line amendment on line 51.
Yes, Madam Chair, Delegate Maldonado, that amendment adds a 15-day cure period for an employer required to post a salary range.
Do we have a motion on the amendment? Do we have a second? Second. All those in favor? All right, no opposed. All right, the amendment is before us.
Thank you, Madam Chair. Madam Chair, members of the committee, if HB 636 looks familiar, it's because it has been before us before. I've brought this bill. This is the third time bringing this bill before the House, and it is a wage transparency bill. HB 636 prohibits the use of salary history in employment decisions by prohibiting employers from seeking, relying on, or using a prospective employee's wage or salary history in hiring, compensation, promotion, or other employment decisions. Using prior pay can perpetuate existing inequities and allow disparities to follow workers from job to job to job, regardless of whether their qualifications and the responsibilities of the role. This often happens with the pay disparities between women and marginalized communities, even folks who come from government to private sector. When relying on previous salaries instead of market salaries, it can often create disparities. By way of example, I want to give you what would happen if we just took a slice of this and looked at, for example, wage disparities between women and men. Each year in Virginia, women are typically paid much less than white non-Hispanic men. But if we were to pay for in equal pay or pay parity, pay for this many months, it would pay for a number of months of rent. So if we paid equally, for Latino women, they would be able to pay for 23 months of rent, more than they already can. For Black women, it would be 19 months more of rent that they could pay if they were being paid equally. For Native American, Indigenous, we would have the ability to pay 23 more months. For white non-Hispanic, 13 months, Asian Americans, 10 months, and Native Hawaiian and Pacific Islander, 22 months. So the differences aren't minuscule. In fact, the disparities across this diaspora are also equally stark. For Latino women, the pay discrepancy is $33,000. For Black women, it's around $28,000. Native American, around $34,000. White non-Hispanic, around $19,000. Asian American, around $14,000. And Native Hawaiian and Pacific Islander, around $31,000. So as you can see, it is an important step in the path of pay equity to make sure that we are sharing what the pay salary ranges are. Also, organizations have budgets for their positions. And what can often happen is there is a budget that is aligned with the market, and somebody comes in and historically maybe they were paid less than what the actual budget is, and they end up getting paid less again. So HB 636 requires employers to disclose the wage salary and wage salary range in all public and internal job postings, including postings for promotions, transfers, and other employment opportunities. It requires employers to set the wage or salary ranges in good faith, ensuring transparency is meaningful rather than nominal. The employer cannot ask the person for their prior wage history, cannot make an offer contingent upon disclosing that wage or salary history. However, if somebody discloses it on their own, they can ask questions about it, but can only use it as a basis to pay more, not less. Current law does not prevent employers from relying on salary history or require wage range disclosures or limiting transparency. This bill addresses these gaps by establishing clear prohibitions on salary history use. I think that I'll stop there because we all can imagine places and times where we have applied for jobs where the salary range has not been disclosed. And we got all the way through the process and then it's disclosed. Had the person known up front, they never would have applied for the job potentially in the first place. So all of this not only helps people seeking positions, but it does also help employers. As somebody who has worked in this space for a number of years, been a manager, hiring people, it costs organizations tens of thousands and even hundreds of thousands, depending on the seniority level of the person, to replace people once they come in at an undercompensated role. They will not stay, and so they have to repeat the costs of onboarding, talent acquisition, and training. So it's good for the organization, it's good for the candidates, and it also helps to balance out the playing field and help it so that Virginians can have fair equity and be able to pay for life's expenses that we have every day. Thank you, Madam Chair.
Thank you so much. Do we have any questions from anyone on the committee? Do we have anyone here to speak in support of the bill? Come on up. Welcome.
Madam Chair and members, Judy Conti on behalf of Virginia Employment Lawyers Association and the Metropolitan Washington Employment Association. I echo everything the delegate said. I just wanted to call attention to a 2025 review of the over 20 state and local laws that have prior salary bans that Boston University School of Law conducted. And it found that newly hired female workers in ban jurisdictions saw salary increases of 7.8% higher. It reduced the racial pay gap by 5.8% to 7.7%. It increased job mobility for hourly workers, particularly those who were scarred by beginning their employment during the recession or during the COVID recession. And it also improved transparency because employers were significantly more likely to include salary information in their job announcements when the bans were in effect. So these are all great outcomes, and we fully support this bill. Thank you.
Thank you so much. Come on up.
David Broder with the SEIU Virginia State Council. We proudly support this bill.
Thank you so much. Welcome.
Hi, Madam Chair, members of the subcommittee, Chrissy Noonan with Seven Hill Strategy Group on behalf of the Virginia Chamber. We appreciate the patron working with us to address our concerns with the amendment, creating the 15-day cure period, and we have no objection to the bill. Thank you.
Thank you so much. All right, any in opposition of the bill?
Good afternoon, Madam Chair, members of the subcommittee. Tommy Herbert, representing the Virginia Restaurant, Lodging, and Travel Association. Also grateful for the right to cure provision in the bill. However, our members have asked us to register opposition, particularly to the applicability of the bill to internal transfers. Thank you so much.
Thank you so much. All right, is there anyone online? There is no one online. All right, any other questions or comments from the committee before we let Delegate Maldonado have the final word? No? All right, Delegate Maldonado, you have the final word.
Thank you very much, Madam Chair. I also wanted to echo the thanks for the Chamber's input. We mean no harm to small businesses. We love our small businesses and believe that they are the backbone of our economy. And so when we can find a compromise that also helps to bring parity and equity, that also helps to protect businesses, we love when that happens. So I hope it will be the will of the committee to pass this bill. Thank you.
Thank you so much. All right. Do we have a motion? Committee operates on motion.
Madam Chair.
Delegate LeVere Bowling.
Yes, I'd like to move to report this bill with as amended.
Second. I have a motion and a second to amend, to report the bill as amended. All right. Clerk, can we open the roll? All right, on a vote of 4-2, the bill is reports. Thank you so much. Delegate Maldonado, do you have another?
Yes, Madam Chair. Next up, my second bill is HB 675.
1 second. Delegate Maldonado. All right, Delegate Maldonado, go ahead. Thank you.
Thank you, Madam Chair. Madam Chair, HB 675 is meant to address some very troubling behaviors that we're seeing, particularly in the climate of our anti-immigrant efforts and what's happening with our immigration and customs and enforcement behaviors in our Commonwealth and across the nation. This bill is to support the Virginia Workplace Protection Act, and the Workplace Protection Act stops employers from threatening workers with immigration reports to avoid paying their fair wages or maintaining safe workplaces. It establishes clear penalties for employers who use immigration status as a weapon against workers asserting their legal rights. This protects all Virginia workers and ensures honest businesses can compete fairly. What does it do? It prohibits employers from threatening workers, as I said, but it also creates a complaint process through the Virginia Department of Labor and Industry with confidentiality protections for the workers. It establishes escalating penalties based on the violation. And it also protects workers who report unpaid wages, unsafe conditions, missing breaks, or other workplace violations. And it levels the playing field for honest businesses by preventing competitors from exploiting vulnerable workers. So this matters. Workers are being silenced. They're being threatened about their immigration status and prevents them from speaking up to earn wages, to receive wages, to be paid wages they have earned, to be able to report on things that are violations for every other kind of employee in the workplace. But for them, they would have to remain silent for fear of immigration bullying or threats. What we like is for this to be in place so that we can make sure that the voice of those who are properly working and who have employment here in the Commonwealth can be safe, can be good workers and contributing to our economy, and also make sure our businesses are doing their part to continue making sure that the business landscape is also safe and productive. Thank you, Madam Chair.
Thank you, Delegate Maldonado. Do we have any questions? Delegate Ballard.
Thank you, Madam Chair. Question for Delegate Maldonado. The very last sentence of that, I'm just kind of curious, where the commissioner or his authorized representative shall have the right to petition a circuit court for injunctive or such other relief as may be necessary for enforcement of this section. And not trick questions, I'm just trying to think, like, injunctive relief of what?
Delegate Maldonado.
Thank you, Madam Chair. Madam Chair, I would say that the injunctive relief has to do with the pressures or bullying or conditions in the workplace that would potentially be happening. So what we are hearing are stories of people who are saying, I am being bullied at work because I have said, hey, this is a violation, or hey, I have an injury and should be compensated. There are certainly many remedies one could pursue, but injunctive relief would help protect them in any given moment.
Delegate Ballard, you have a follow-up?
Just brief follow-up. So, I mean, so the commissioner would petition a circuit court and basically say, we want you to stop them from harassing and bullying based on their status? I mean, I guess I'm just trying to sort this through in my mind. It seems like that's redundant of what the overall statute is trying to do, which provides penalties for doing the same thing. So why do you need to go to circuit court and get an injunction?
Delegate Maldonado.
Madam Chair, I would say that I think that anybody who's ever been in these situations should have the choice between getting injunctive relief to stop the behavior, as well as pursuing any kind of civil remedies like fines, payment of fines for penalties of behavior.
Delegate Ballard.
One, Madam Chair, and I'm sorry, Delegate Maldonado, I'm not trying to harass you here. So could the commissioner petition the circuit court for something, say, intentional infliction of emotional distress or negligent infliction of emotional distress on behalf of the employee, and seek monetary damages through the circuit court process?
Delegate Maldonado, do you want to?
I would like to, I was just going to say, thank you, Madam Chair, and I thank the delegate for the question. I would like to defer to council to clarify.
Sure.
Or
Madam
clerk.
Chair, Delegate Ballard, Delegate Maldonado, the text of the bill, says petition a circuit court for injunctive or such other relief as may be necessary for the enforcement of this section. So that leads me to look at only the text of the section, which no employer shall use coercion or issue a threat to an employee based on immigration status in furtherance of committing certain violations of employment law. So I would imagine that the injunctive relief would relate to that violation of this section, so that coercion or threat.
Yeah, so follow-up question for council, Madam Chair. So, okay, so that makes sense. So if I'm understanding you correctly, the commissioner could petition the circuit court for injunctive relief or any other relief available at law just pursuant to this section. It wouldn't give the commissioner or authorized representative the ability to access other, like, torts, for example.
Like council answer. Yes, thank you, Madam Chair. I do not see any authority to start an action for a tort or specifically for infliction of emotional distress. Thank you. Thank you. Any other questions, committee members? All right. Anyone here to speak in favor of the bill? Please come up. Welcome.
Judy Conti on behalf of Vila and Mawila. I have been practicing employment law on behalf or representing workers through public policy on behalf of low-wage workers for over 30 years. And the degree to which immigration status, even people who are lawfully present in this country but may not be full citizens yet, is used against them to bully them, to drive down working conditions for all workers is really astounding. And in particular, in the past year, it has become even more weaponized for reasons that we all well know. This is an important bill that not only protects immigrant workers from the sort of harassment and bullying that Delegate Maldonado talked about, but also protects all workers who have low-wage workers in particular with authorization to work or who are full American citizens, because then low-road employers can't purposefully hire people they know they can bully, intimidate, and pay lower wages to. So I have often said if you want to protect America's workers, you have to protect all workers in America, and this bill will do that. So we proudly support this bill and urge its enactment. Thank you.
Thank you, ma'am.
Hello, my name is Melissa Solano, and I'm here with We Are CASA to support House Bill 675. As the daughter of immigrants, I see the fear and uncertainty in our families and communities. No one should have to choose between a paycheck and their safety. Supporting this bill means our immigrant workers can feel safe, our families protected, and our communities stronger. We are hard workers, and we should not fear coercion and abuse. This bill aims to protect us. Please vote yes to give dignity, fairness, and security to all. Thank you.
Thank you very much.
Christian Martinez, Research and Policy Analyst at We Are CASA. I would like to align our comments with that and thank the patron for championing this legislation. Thank you.
Thank you.
Manuel Gago from Legal Aid Justice Center. We support this bill because stop employers for using immigration threats to silence workers, ensuring everyone can safely speak up about wage theft and unsafe conditions. Thank you.
Thank you.
Good afternoon. Kayla Mock with the United Food and Commercial Workers Union, Local 400. We proudly stand in support.
Thank you.
Good afternoon, Mr. Chairman, members of the subcommittee. David Berger with the SEIU Virginia State Council. We proudly support this bill to ensure that all hardworking families are protected.
Thank you very much. All right. Anyone to speak in opposition to the bill? All right. Anyone online?
No, sir.
So the bill's back before us. Any questions or comments from members of the committee? All right. I believe this bill has to go to, does it have a letter?
Yes, sir.
It does
It does have a letter to go to appropriations.
Yes, sir.
Moved and seconded to, no, so moved and seconded to report and refer this bill to appropriations. Let's go to the big board. All right. By a vote of 7-0, this bill is reported and referred to appropriations. Delegate Maldonado, before we move on, I'd like to go back to HB 636 for a moment, and I'd like to roll HB 1164 from Delegate Nicole Cole into HB 636. Is there a motion? Second. Moved and seconded to do that. All those in favor say aye. Aye. All those opposed? All right. That bill is incorporated into 636. Then also there's a final bill, Delegate Maldonado, that is HB 948, which is very similar to a bill that was passed out of this committee. It's already passed the House. So I would, if you'd like to strike that bill. Move to strike that bill. There's a motion a motion that's been moved and seconded to strike that bill, HB 948. All those in favor say aye. Oh, that's actually online. I apologize. Up on the board. All right. By a vote of 6-0, that bill is stricken from the docket. Thank you very much, Delegate Maldonado.
Thank you, Mr. Chair, members of the committee. I'd also like to thank CASA for their help on the wage coercion bill, for being such a great advocate partner on that. Thank you.
Thank you, Delegate. Delegate Keys-Gamarra. You have HB 121 and also HB, oh my goodness.
1481.
1481. Which one would you like to do first?
1481, if I can.
1481 first.
Okay. I'm going to say good morning. Good afternoon, Mr. Chair, members of the committee. 1481 is a simple, really a notice bill to make sure that when employers have more than 10 employees, they notify the Attorney General or the EEOC in writing of any employee complaint alleging harassment, sexual harassment, or any other form of discrimination, and to make sure that the employee understands those deadlines to file complaints. It is simply to make sure that employees are not foregoing their rights under those particular opportunities when they may experience discrimination. And we're just simply trying to preserve that, and I would hope that it would be the will of the body to report this bill. Thank you.
Thank you, Madam. Thank you, Delegate Keys-Gamarra. Any questions or comments from members of the committee? All right, anyone here speak in favor of the bill?
Judy Conti on behalf of Viola and Mawila, and we support the bill.
Thank you very much. Anyone else to speak in favor of the bill? Anyone speak in opposition to the bill? Once again, if you're going to speak, please come close. It's fairly clear when we're going to act. So, ma'am.
Good afternoon, Mr. Chairman, members of the subcommittee. Thank you so much to the patron for working with stakeholders on this. I'm Melissa Aslan on behalf of TechNet. We really do appreciate the patron. She's done a lot of work on this bill. However, we still have some small concerns and have to sadly be opposed at this time. Thank you.
The employer bill? I only talked to TechNet about the other bill.
We're doing 1481.
My apologies.
It's good to see you, though.
All right.
Sorry, everybody.
It's been fun.
I really do apologize.
All right.
Thank you.
Are you
In the chamber.
Yes, ma'am. I will be here for both, actually, but Ethan Betterton, Virginia Chamber of Commerce, do have some concerns about the administrative impact on Virginia's businesses, but look forward to working with the patron if the bill moves forward. Thank you.
Thank you very much. All right. Anyone online for this bill? All right. The bill is back before us. Move to report and second. All those in favor say, oh, sorry. There's no more questions or comments from the committee. All right. Motion is to move and report this bill. Let's make sure there's no move and report. Let's go to the big board. All right, by a vote of 5-2, this bill is reported. Excellent. The first bill on our numerical docket, Delegate HB 121.
Thank you. Members of the committee, this bill came to my attention through a number of avenues, starting with training, but also personal experience in trying to shop for my own children. And I noticed that when I went to the store, there was one price for an item. When I stepped outside of the store and checked on my phone, it was a different price. And when I went to my home computer, it was a higher price. And I realized, as I had been trained at NCSL, that this was called surveillance pricing, which meant that there were folks who were watching our patterns and therefore charging me in accordance with that. As a result of that, this bill has been designed to try to eliminate or minimize any discriminatory pricing, and it is an area that a number of states are concerned about. As a result of my work with a number of stakeholders, my door has been open. I have tried to accommodate pretty much every amendment that made sense. And we landed on prohibiting price increases under those circumstances, price increases that would be based on individual data, merely to limit discriminatory pricing. I understand that we made a lot of progress, but there is still not peace in the valley. And although it pains me to say, quite frankly, given the amount of work that has been done and the need to protect consumers, I would ask that this bill be carried over to 2027.
Thank you, Delegate Keys-Gamarra. Is there a motion to so move? It's been seconded. That is to carry over. That is a voice vote. All those in favor of carrying over HB 121 to the 2027 session, please say aye. All those opposed? Thank you, Delegate, very much. All right, Delegate Reed.
Mr. Chair, thank you very much. I feel like an underachiever. I only have one bill.
No, there we go.
This is House Bill 406, and there should be a substitute before you.
Moved and seconded, substitute before us. All those in favor say aye. All those opposed, substitutes before us.
And then, Mr. Chair, because this is dealing with workman's compensation, I was alerted to an error on line 24 that if the committee is so willing, after the word wage, strike during the previous 3 years. That would be acceptable to me as a friendly amendment because that apparently is in conflict with the code reference earlier in the document.
Could Council please repeat that amendment change?
Yes, Mr. Chair, Delegate Reed, just to confirm, on line 24, after weekly wage, strike during the previous 3 years.
Yes, that would be correct, Mr. Chair.
Is there a motion to accept the amendment? Moved and seconded. All those in favor say aye. All right, the amendment is before us.
Okay, so Mr. Chair, members of the subcommittee, thank you very much for your indulgence on that. As this originally started, it was really much more comprehensive and broad, and it was probably me conflating some line of duty items together with workman's compensation. Now this is all in the workman's compensation part of the code, and I want to tell you how this came to me because this is one of those examples where we like to talk about some of the best ideas come from constituents. And we had a Loudoun County Sheriff's officer who was injured in a motorcycle accident. And of course, this was really very detrimental to him and his family. He's okay now. But at the same time that this was happening and he was going out on workman's compensation, there was a need for his spouse to be able to stay at home with him, at least initially, temporarily, to be able to help take care of him. And because the code currently doesn't provide for workman's compensation for that spousal support, it meant that there needed to be a GoFundMe page created to be able to help fund the time that she would be away from work. And the constituent said to me, why is it that a law enforcement officer can be out and be receiving workman's compensation and then they need the support of their spouse until they get a medical doctor's prescription for 24/7 ongoing care while they are rehabilitating. And so that was the idea behind this particular piece of legislation. And what we've done now is this has been much more narrowly tailored so that the spousal workman's compensation would be 12 weeks or until a 24/7 provider is available, the lesser of the two, so that we're not really going off for a long period of time. It mirrors the rest of the workman's compensation schedule, where it would be 66 2/3% of the salary of the spouse that they're out. And most importantly, I think, is that it requires a doctor's order that they need that immediate care so that we can avoid any potential type of abuse. So, Mr. Chair, that is the bill that is now before you, and it's much different than the one that was originally introduced. And I appreciate everyone who has worked with me to get it in what I believe to be a much better position.
Yes, that is a much different bill. Any questions or comments from members of the committee? And you have done a lot of work on this.
Thank you, Mr. Chair, and I appreciate your time.
Delegate Runyon.
Clarification I made, Mr. Chair, of the patron. Do I understand that in other cases, spousals, in circumstances, if this was not a law enforcement officer in just a conventional workers' comp place, their spouse would be eligible in the same circumstance, or are we creating a new class of coverage?
Delegate Reed.
Mr. Chair, I am just specifically trying to address law enforcement officers who are injured and are receiving workman's compensation and would need short-term spousal support. I have not looked at the rest of the code to see whether or not that there would be an opportunity for some future legislation.
Okay. Delegate Runyon.
To follow up, I apologize for not asking the question clearly. So currently, no spousal support is available throughout workers' comp. This would be a new class of payments?
Mr. Chair, I'd have to ask somebody. I think we have one of the commissioners from Workman's Compensation.
There we go.
Mr. Chairman, Wes Marshall, Chairman of the Virginia Workers' Compensation Commission. Just to clarify the question, there is a possible capability for a spouse to be compensated for giving in-home care, but there has to be a demonstration of medical necessity, and the person doing it under the case law, they have to basically be a nurse or somebody who is trained and qualified and certified to give that care. The only circumstances where that really has come up is where let's say the husband gets hurt, the wife is a nurse, the doctor says you need in-home care, and everybody agrees the wife will do it. It's not fair for her. If she was doing it at work, she'd be compensated for it. Not fair for her to do it at home and not be compensated. But that's all case law. There's no statute. It's a new type of benefit. Thank you.
Thank you, sir. Any other questions from the committee? All right. Anyone here to speak in favor of the bill?
Mr. Chair, members of the subcommittee, David Oswingle, Virginia State Police Association, and our association supports the bill. We've had several members that come to mind that have fallen into this exact situation where the spouse has had to leave work in order to care for the law enforcement spouse. And oftentimes they have to give up their employment, their source of income to be able to do so. We've tried as an association and a charity to step in and fill this gap. This would be a really valuable tool for them to be able to get well and get back to work. Thank you.
Thank you, sir. Anyone here to speak in opposition to the bill?
Mr. Chairman, members of the committee, I guess you assume I usually oppose these. Want to thank the patron. He's been very generous. We've been by several times. We just wanted to kind of clarify and get this to match up kind of with what the claimant receiving the workers' comp would get and make it consistent with other parts of the code. We did just get the substitute. I think it has a lot of that in there, and we're going to look it over. So I do have no position, just because we haven't had a chance to review it in full. But I just want to thank the patron for his time. So
thank you, sir.
Thank you.
All right. Any other questions or comments from members of the committee? Committee works by motion. Oh, is anybody online?
No, sir.
Committee works by motion. Didn't think so. Yes, it does. So there is a letter that this has to go to appropriations.
Speaking to
Delegate Fowler.
Thank you. As a law enforcement spouse, thank you for putting this in. If my husband couldn't work and I could take care of him, and to have that ability to be able to be compensated and not have to take away from work would be extremely monumental, I think, in a spouse, in the whole law enforcement family. So thank you so much, and I appreciate the work that you've done on this bill. And with that, I'd like to motion to report and refer to appropriations.
All right, so.
Move the substitute and refer, I'm sorry.
Yeah, that's right.
Report the substitute and refer to appropriations.
There we go. So the motion is to report the substitute and refer it to appropriations. Let's go to the big board. All right, by a vote of 6-0, this bill is reported and referred with substitute to appropriations.
Thank you, Mr. Chair. Thank you for working with me, everybody. Thank you.
Thank you. Delegate Anthony, who has been incredibly patient.
Thank you, Mr. Chair, members of the committee. Before you have House Bill 1451, and I do have a committee substitute.
Moved and seconded the substitute. All those in favor of the substitute say aye. All those, that was a very peaked aye. All right. There we go. Everyone in the audience. Aye. No. All right. So the substitutes before us.
Thank you, Mr. Chair, members of the committee. If I could actually retitle this substitute, I probably would call it the Employee Performance Transparency and Safety Act. I guess I would invoke Carly Simon and try to sing that you think this bill is about you, but it's not.
Okay.
So, Mr. Chair, House Bill 1451, as substituted, addresses employee performance transparency and workplace safety. Haha. I'm offering this committee substitute that substantially narrows the introduced bill. The substitute removes industry-specific language and focuses the bill on a single forward-looking objective, ensuring that employees have reasonable access to information about performance standards or systems that are already used to evaluate their work, which is, for most, already in practice. The General Assembly does not legislate only after something breaks. It acts prospectively to build information and safety infrastructure so that if concerns arise in the future, the policy decisions are informed by facts rather than assumptions. So as substituted, this bill does not regulate productivity levels, does not set or limit performance standards, and it does not dictate how employers manage their operations. Mr. Chair, it does not mandate any specific technology, reporting system, or data format. Employers retain full flexibility in how performance systems are designed and implemented. The substitute is limited to transparency and access. So where performance systems are already in use, employees must be able to understand what applies to them and how they are evaluated. And so the substitute also includes an accessibility safeguard. If performance information is provided electronically, access may not be limited solely to an employee's personal electronic device. We want to ensure that is equitable access while allowing employers to continue using existing internal systems, workplace terminals, employer-provided devices, or printed records upon request. And so let's address some of the concerns that I have many folks bombarding my office about, Mr. Chair. The substitute is intentionally narrowed. It is not a labor regulation bill. I repeat, it is not a labor regulation bill. It does not impose operational mandates, and it does not interfere with business models. The substitute does not require ongoing reporting to the Commonwealth, real-time data submission, or production slowdowns. It relies on information employers already maintain internally. The substitute avoids this one-size-fit-all approach. It does not prescribe any metrics or any type of data fields or systems, recognizing that different employers and sectors, they operate differently. And so this is basically industry neutral, and the industry-specific framing has been removed. There are no specific NAICS codes embedded in this substitute. The bill applies neutrally based on covered practices, not company name, sector, or geography. This bill is not about you. Again, the substitute is practice-based, not sector-based. Coverage is tied to the use of employee performance or automated evaluation systems. So not to warehouses as the category, or ports, or logistics, or any enumerated NAICS classification again. So if an employer uses covered performance systems, the transparency requirements apply. If they don't, the bill does nothing to them. And so that is why in Section 2, we put an uncodified directive. Section 2 directs the Department of Labor and Industry, AKA DOLE, to convene a time-limited work group to assess the use of employee performance systems in the Commonwealth and to review any available Virginia-specific information related to transparency and the workplace safety. This directive is intentional. So rather than legislate based on speculation or out-of-state models, the General Assembly is ensuring that any future decisions are grounded in Virginia data. And so the work group uses existing resources, includes employer and employee stakeholders, reports to the General Assembly, and sunsets automatically upon submission of that report. And so, Mr. Chair, the substitute represents this measured transparency first approach that balances worker access, employer flexibility, and sound policymaking. So I respectfully ask, in this case, that House Bill 1451 be continued to 2027 with a letter to DOLE as referenced in the enactment clause. Thank you, Mr. Chair, members of the committee.
Delegates, the delegate has asked that the bill be continued to 2027 with a letter from me to DOLE. I am happy to do that. This is a voice vote. Do we have a motion? Moved, and is there a second? Second. Moved and seconded. All those in favor of carrying the bill over till 2027, please say aye. Aye. All those opposed? All right. Thank you very much, Delegate. We greatly appreciate it.
Thank you, Mr. Chair.
All right. Once again, because of the crazy nature of this afternoon/evening, I'm going to hand the gavel over to Delegate Converse-Fowler. The next individual up will be Delegate Martinez, then Delegate Rasool, then Delegate Garrett, and we should be coming back soon. So thank you very much.
All right, Delegate Martinez, which bill would you like to start with? 13?
I will start with 1320 if that's okay, Madam Chair.
1320, Delegate Martinez.
Thank you, committee and Madam Chair. What this bill does, it makes a one-time $48 increase to all weekly unemployment benefit amounts. Last year, the General Assembly passed a one-time $100 increase to weekly unemployment insurance benefits amount and authorized a study about indexing benefit amounts to a statewide metric. The bill was a recommendation of the Commission on Employment Compensation and consistent with a policy option from JLARC in their 2021 report on the Virginia Unemployment Commission. The $100 amount was the one-time increase and was scored, vetted, and voted favorably by the 2025 General Assembly. Then Governor Youngkin reduced the increase by $48. This bill just makes up the difference and importantly increases Virginia benefit adequacy while the work to index benefit accounts to a statewide metric proceeds. Increasing weekly unemployment benefits amounts matters for two reasons. First, Virginia's unemployment benefits are still too low to assist workers in covering basic necessities. Weekly benefits amounts for workers who file a new claim in 2026 range from $112 to $430 a week. The state's maximum weekly benefit is currently less than 30% of the state's average weekly wage. In 2025, as compared to 52 other states and territories, Virginia's replacement rate, proportion of wages replaced by UI benefits, was ranked 42nd. Unlike 29 other states, Virginia benefit amounts do not currently increase based on a statewide metric. So the sufficiency of benefit amounts erodes over time. Insufficient benefit amounts curtail the unemployment insurance program's ability to stabilize the state economy. Second, Virginia benefits may be too low to prompt some eligible unemployment workers to apply for unemployment insurance compensation. Only 14 out of every 100 unemployed workers in Virginia receive unemployment insurance benefits. This is not only bad for workers, but also bad for employers. Since unemployment insurance keeps workers attached to the labor force through reemployment assistance and requirements to conduct work searches, make out job contacts, and accept suitable work. This bill is supported by a working group made up of Social Action Linking Together Virginia Poverty, Social Action Linking Together, Virginia Poverty Law Center, Legal Aid Justice Center, the Commonwealth Institute for Fiscal Analysis, and National Employment Law. I do have a stakeholder who's willing to answer questions.
Thank you, Delegate Martinez. Do we have any questions from anyone on the committee? All right, let's go. Do we have anyone in here to speak in support of the bill? Please come up. Just be mindful of the time so last person doesn't have to say nothing.
Good afternoon, Madam Chair and members of the committee. I'm Flannery O'Rourke on behalf of National Employment Law Project, speaking in support of the bill. The purpose of unemployment insurance, or UI, compensation is to provide wage replacement for workers and to protect the economy by allowing workers to maintain household spending. To meet both aims, UI benefits should replace at least 50% of a worker's prior wages. That's the floor. Well, if 50% is the floor, then our benefits are 6 feet under. Because according to the U.S. Department of Labor, the last time the state met this metric was in 2003. Last year, the General Assembly supported a one-time, across-the-board $100 increase, which the governor then reduced to $52. This bill just makes up the difference. This bill alone is not going to get us to 50% wage replacement for most workers, but it will bring another additional $200 in their pockets each month, which in turn will better protect the economy. So please support this legislation. Thank you.
Thank you.
Good afternoon, members of the committee. My name is Charles Kelly. I'm the business manager for International Brotherhood of Electrical Workers, Local 666. We're by nature subject to the vagaries of the economy, and construction is up and down. We support this measure.
Thank you.
Madam Chair, Jason Parker, Virginia State Building Construction Trades Council. Associate my comments with Business Manager Skelly's.
Thank you.
Good evening, Madam Chair, members of the subcommittee. My name is Joanna Darkus with Virginia Poverty Law Center. I'm going to keep it simple. Benefit amounts must increase if the UI system is to achieve its principal objective to alleviate hardship for the unemployed. We support this bill and ask you to do the same. Thank you.
Thank you so much.
Pat Levy-Lavelle, Legal Aid Justice Center. We support this bill. As Delegate Martinez has noted, this makes whole the $100 that was approved by the General Assembly and vetoed last year by Governor Youngkin. The $48, again, just adds to the $52 that eventually did pass last year to bring that policy to fruition to help workers, employers, and the economy. Thank you.
Thank you.
Chairwoman and members of the committee, my name is David Smith with SALT, Social Action Linking Together, and for all the reasons mentioned earlier, we support this bill.
Thank you.
Judy Conti on behalf of Vila and Moila, and we support the bill and thank the delegate for his championing it.
Thank you.
Good evening, Madam Chair, members of the subcommittee, David Broder at the SEIU Virginia State Council. We support this bill as a good common sense measure to support Virginia's working families.
Thank you. Is there anyone here to speak in opposition of the bill? Anybody online? All All right, back to the committee. Any other questions or comments from the committee before we give Delegate Martinez? Delegate Runyon.
Thank you, Madam Chair. Question of the patron, Madam Chair. Unemployment is funded fully by the employers, both small and large, and there's a threshold of how many dollars until the taxes are fully filled. With this additional $48, will there be an unemployment tax increase required to make the fund remain solvent?
Delegate Martinez.
Madam Chair.
Actually, could council address the question? Is that question something that we could?
Yes, Madam Chair, Delegate Ballard and Delegate Martinez, there's a third enactment clause, and it represents the impacts to the solvency level of the trust fund and the projected average annual increase in the tax liability of employers. The printed bill is so long, so if you go all the way to page 78, if you're looking at the full bill with the tables, that third enactment clause.
And also, I'll add, Delegate Runyon, it does have to go to appropriations. We have a letter here as well. And do we have an expert here that wanted to? Can you go ahead and let us know where you're from, who you are, where you're at?
Yes, I'm Flannery. Thank you, Madam Chair. I'm Flannery O'Rourke, National Employment Law Project. Yes, it's included in the enactment clause that it was indeterminate. I think you also will see in that enactment clause that there was an expected impact to solvency. I want to provide a little bit of context for that. So when VEC ran the analyses for the enactment clause, they did so based on no tax rate adjustment. Of course, you know that the committee members know that state unemployment insurance taxes are not a flat tax. It's adjusted every year. And actually, VEC is required under Virginia Code 60.2-111, to be precise, to adjust them every year. And there's three main factors. The primary one is the experience rating. That's required under federal law. And so basically, the more workers that an employer lays off, the higher their tax rate, up to a cap. So it's largely in the employer's control. So an imperfect analogy in terms of the current third enactment clause, what it says for solvency, is it's sort of like if I tested how cold my apartment gets without turning the heat on, right? I'm going to tell you what's going to happen. It's going to get cold, right? So I asked VEC, well, what if we turn the heat on? What if you adjust the tax rate within the tax scheme? And I asked, could solvency be maintained above 50% with tax rate adjustments? And they said, yes, it is possible. And based on this analysis, it is also likely. I'm quoting there. So I think that's the answer that you're looking for. And I want to say, yes, employer taxes could be adjusted up, but as I said, the primary factor would be within their control. And the other piece that I will say is that from the most recently available U.S. Department of Labor data, the average employer tax, the average tax cost per employee per year is $51 versus a nationwide average of $286 per employee per year. So it is, Virginia will still have some of the lowest tax costs per employee, even with this bill.
Does that answer the question, Delegate Runyon? All right. Anyone else?
No, Madam Chair.
You have a follow-up?
Follow-up.
Delegate
yes,
Runyon?
Thank you. Yeah, and I do appreciate that, and it's late of the hour late, so I will try and minimize my words. But in short, yes, the taxes will go up. And Madam Chair, may I speak to the bill?
Are we at that point? Yes. Go ahead, Delegate Runyon.
Thank you, Madam Chair. And I do appreciate the bill being brought forward and recognize that, but I am disappointed that the small business community has not really had an opportunity to weigh in on this. And I think we're in an economic circumstance that those dollars do matter to a small business employer. The larger employers may very well be able to handle this, but the small business employers, those few dollars that goes up per employee matters. So I do think, thank you that, and it's important to me that we all recognize this is a tax increase that we're imposing on our small business community. Thank you, Madam Chair.
Move to report and refer to appropriations.
Motion to move to report the bill and refer to it to appropriations has been put forward. It's moved and seconded. Let's go to the big board. All right, by a vote of 5-2, the bill is reported and referred to appropriations. Delegate Martinez, you have another bill.
Yes, Mr. Chair. What this bill does, you know what I did? I pulled up the wrong bill. Let me start over. HB 1319 comes from a recommendation from the National Employment Law Project. This bill sets the maximum potential benefit duration for unemployment insurance at a uniform 26 weeks for all claimants. This should look familiar to those of you who were last year as it passed the General Assembly. The maximum potential benefit duration is the total number of weeks a worker can receive a weekly benefit payment if they meet multiple requirements for each week. Make a claim for benefits that week, meet all weekly requirements for unemployment insurance, including weekly work searches and job contacts, and remain unemployed and unable to find suitable work. Under current Virginia law, a claimant's maximum potential benefit duration ranges from 12 to 26 weeks. A claimant's maximum potential duration within that range is not determined by whether the claimant remains unemployed. Instead, it is determined by the ratio of the claimant's highest two-quarter earnings to their total earnings during the year-long base period. This does not make much sense as unemployment rates and duration vary greatly by region, industry, and demographic characteristics. Over the past 2 years, roughly half of the Virginia claimants were entitled to 26 weeks maximum potential benefit duration. Setting a uniform maximum potential benefit duration will ensure our law is more sensible and fair so that all Virginia claimants receive support for the weeks they need it. Ensure that the local economy does not suffer as much from large layoffs, and household spending does plummet in the direct relations to the loss of unemployment insurance benefits. Thus, by setting the maximum potential benefit duration at 26 weeks for all claimants, the bill does not and cannot extend the period in which a worker is unemployed. Instead, it ensures that Virginia claimants and Commonwealth economy don't go broke when suitable work takes a little longer to find. It is no wonder that West Virginia, D.C., and Maryland already have a uniform 26-week maximum potential benefit duration. We do have some stakeholders to support the bill, and I will defer to them for any questions. But before I do that, personally, being a government contract for almost 30 years, you're only as good as your contract. And there were many times that our contract ran out, we lost the rebid, I had to go on unemployment, and having to meet all these requirements became burdensome as I was looking for jobs. What this does, it relieves me and other unemployed, that it would have relieved me and other unemployed workers, at least knowing that they can start with 26 weeks benefit and not worry about having to reapply to extend it and just go out and look for a job. Thank you, Mr.
Thank you, Delegate Martinez. Are any questions or comments from members of the committee? All right. Who's here to speak in favor of the bill?
Thank you, Mr. Chair and members of the committee. I'm Flannery O'Rourke on behalf of National Employment Law Project. Unemployment insurance entitlement is determined upon application and for each week claimed. But the maximum number of weeks a worker can claim is determined only upon application. In Virginia, the maximum could be anywhere from 12 to 26 weeks based on an earnings formula that has nothing to do with how long it takes to find suitable work. So thousands of workers get arbitrarily cut from financial and reemployment supports in as few as 12 weeks, even though they meet the stringent federal and state weekly requirements. This directly harms those workers and every worker, business, and government that relies on that worker's wages. So if I get laid off and my benefits get cut off, then those small businesses that we're concerned about will lose my patronage because I have no wage replacement. It's like deprivation dominoes. This bill prevents said deprivation by supporting all otherwise entitled workers for up to 26 weeks.
Thank you, ma'am. Sir.
Mr. Chair, members of the committee, Patrick Brigham, IBW Local 666. Just want to echo Charles's comments from the previous bill. This bill will help our members keep their feet on the ground while they wait for the next construction job to start. We support the bill. Thank you.
Thank you.
Mr. Chair, members of the subcommittee, I'm Joanna Darkus with Virginia Poverty Law Center. We support helping job-seeking workers make ends meet, and we hope you will too.
Thank you.
Mr. Chair, members of the committee, Judy Conti on behalf of Vila and Mawila, and we support the bill and thank the patron for his sponsorship.
Thank you.
Mr. Chairman, members of the committee, David Smith with SALT, Social Action Linking Together, and for all the aforementioned reasons, we support this bill.
Thank you.
Good evening, Mr. Chair, members of the subcommittee. My name is Pat Levy-Lavelle, Legal Aid Justice Center. We support the bill. Thank you.
Thank you.
Mr. Chair, members of the subcommittee, David Broder, SEIU Virginia State Council, we support this bill.
Thank you. All right, anyone speak in opposition to the bill? Excellent. I don't believe there's anyone online. All right, any more questions or comments from members of the committee? With that, the committee works by motion. Moved and seconded that the bill be reported. All right, let's go to the big board. And we can't. Let's go at ease for a moment. Back at ease. All right. Once again, the bill from Delegate Martinez, HB 1319, has been moved and seconded to report. Let's go to the big board. All right. By a vote of 5-2, this bill is reported. Thank you, Delegate Martinez.
Mr. Chairman, may I indulge? I wanted to make a comment that was, address a comment that was made earlier on the first bill, and if you don't mind. It will be quick.
Okay.
Okay. First off, in the last 2 years since I proposed this bill, I've talked with several small business organizations, and not one has ever complained about what we were doing. Second, the total cost for businesses is $22 per year, at least that's the estimated cost, $22 per year, which goes less than $2 a month for the employer to make sure that their employees are taken care of.
Thank you, Delegate Martinez. Delegate Rasool, there's been a lot of work on this bill, a lot of good work.
Thank you, Mr. Chairman, members of the subcommittee. We have a substitute for your consideration.
Substitute, like somebody move the substitute? Moved and seconded. All those in favor of the substitute being before us, say aye. All those opposed? All right, substitutes before us.
Thank you, Mr. Chairman. A lot of people have come together. Apprenticeships, they're good. We love them. We're expanding them, making them more accessible. The substitute before you says that 16 and individuals 16 years or older can be in apprenticeship program so long as that they've got good grades, that they're registered appropriately, and that the potential employer is following the appropriate law. Happy to answer any questions, Mr. Chairman.
Thank you, Delegate Rasool. Any questions or comments from members of the committee? All right. Anyone here to speak in favor of the bill? Guys, come on. Get close.
Mr. Chairman, members of the committee, Alan Siebert, Roanoke City Public Schools. We thank Delegate Rasool for bringing this bill forward. Students crave relevance in their learning. They enjoy learning more when it's relevant. Work-based learning opportunities do precisely that. This bill is based on legislation brought last year by then Delegate, now Senator Jones, which provided this age limitation for cosmetology and barbering. And so our CTE staff were excited about seeing other students have the similar opportunity to expand and increase. We've had the great opportunity to work with multiple organizations to help ensure that concerns are addressed. We appreciate that collaboration because we in public education have no interest in seeing children in harm's way. So we were absolutely thrilled and happy to put in other provisions to help ensure that safeguard was there. We urge that you would please report the bill.
Thank you, sir.
Mr. Chairman, members of the committee, Todd Park, Virginia Education Association. We support this bill with the substitution, which ensures that students still work towards graduation and maintain good grades. Thank you.
Thank you, sir.
Good afternoon, Mr. Chair, members. Ethan Betterton, Virginia Chamber of Commerce. We support the bill. I think it will help improve workforce development and workforce talent pipelines, a core priority for the Virginia Chamber. So urge you to support. Thank you.
Thank you, sir.
Brandon Robinson, Associated General Contractors of Virginia, and for all the reasons stated, we support the bill.
Thank you, sir. Anyone speak in opposition to the bill? All right. The bill is back before us. Any more comments or questions from members of the committee? Move to report. Moved and seconded with the substitute. All right, let's go to the big board. All right. By a vote of 7-0, that bill is reported with substitute. Thank you, Delegate Rasool.
Thank you, Mr. Chairman, members of the subcommittee.
Before we go to Delegate Garrett, there's one item we need to address. Delegate Thomas's bill, HB 1355. That bill has been asked to be laid on the table. Can we get a motion? Moved and seconded to lay that bill on the table. Let's go to the board. Right. HB 1355 has been laid on the table. All right. Delegate Garrett, thank you for your patience.
Dude, I'm just grateful to be here, Mr. Chairman. HB 984, I will tell you that I have, gosh, I got a bunch of ones, and I was gonna give one to each member of the subcommittee, Mr. Chairman, but Jenny, who keeps me out of trouble, said that I would probably get in trouble with ethics for doing that. What HB 984 does is ensures that where a business has a human employee, there's a mechanism for accepting cash payments. And the reason I wanted to hand everybody a $1 bill, and even if you're in the audience and you got a piece of currency, if you pull it out, it says, and I quote, "This note is legal tender for all debts, public and private." And indeed, I believe it is the law of the land that cash is in fact legal tender for all debts, public and private, and yet nowadays we see more and more often entities that won't accept cash. This became really apparent to me during COVID. I used cash sometimes, and I went to the movies. I was happy the theater was open, frankly. And they said, "Hey, we don't take cash." And I was like, "Well, what?" And I think I literally said, "But it says this note legal tender for all debts, public and private." So y'all are like, "Well, what's Garrett doing here?" This is something that when I got to thinking about it, I thought this is good policy and it ought to be bipartisan. When we researched this bill, what we learned is that people who depend upon cash tend to be disproportionately low-income households. They tend to be disproportionately seniors. It tends to happen primarily in urban, not suburban, and rural areas. And it tends to impact people without credit access disproportionately, obviously. It ensures the participation in everyday commerce, regardless of banking status. And so these are all things that I think that we could agree are good without regard to partisanship. I'd also like to point out that this has been done in a lot of places. I say a lot. I'd like to read the places where it's been done. Massachusetts, New Jersey, Rhode Island, Connecticut, Colorado, New York State, New York City, the city of Philadelphia, the city of San Francisco, and the city of Washington, D.C. And the reason I point that out is everybody in this room is pretty smart, and those are places that don't tend to vote like Delegate Garrett, right? But I think that the most important thing to know is that none of us know everything, including myself, and that when you get people who tend to have completely adverse political ideologies who agree, maybe you're onto something. And so it doesn't ban digital payments. We had an entity come by, and I think at some point, Mr. Chairman, I'm way remiss. I should ask for a movement of an amendment or a substitute. But they said, hey, we're concerned that our small business people might have kiosks that this would affect. So we changed the bill so that it wouldn't require that you change your kiosk or whatever. Only businesses where there's a human being present. So, Mr. Chair, at this time, and I apologize to staff for getting ahead of myself, I think there's an amendment that needs to be moved.
Is it an amendment or a substitute, Mr.?
I think it's an amendment in the nature of a substitute.
It's actually just in the nature of an amendment, sir.
There you go.
Line amendments, to be clear. So on line 271, it says that the provisions of that section don't apply to retail sales at a retail establishment that do not have an individual accepting payment in person.
Yeah, and again, I apologize to you.
No need, thank you.
Just proving once again that I don't know everything, as if y'all needed that.
All right, so a motion on the amendment? Moved and seconded. All those in favor say aye. Aye. The amendment's before us with the bill. Delegate Garrett?
It's right.
No?
So, Mr. Chairman, in conclusion, I'll point out again, right, that no matter what we think, federal law is that this note is legal tender for all debts, public and private. That's why it says it on there. And so it just galls me, and I know members of this committee, I know people on both sides of the aisle who are frustrated when, you know, Virginia can take steps to address the realities with example, perhaps to cannabis, but we still got it as a Schedule I controlled substance, right? Like, we should have laws on the books that we're willing to enforce, and if we're not willing to enforce them, we should change them. This would bring Virginia in line with the current federal law on the books. I know that groups might oppose this who I normally agree with, and with all due respect to those wonderful groups that advocate for great things, I think I'm right, or else I wouldn't be carrying the bill. But just, if nothing else, we start this discussion, because I think this is something that at some point we can get some bipartisan consensus on.
Thank you. Delegate Helmer. Oh, never mind. That was odd. Delegate Ballard.
Thank you, Mr. Chairman. Question, Delegate Garrett. So, I mean, I'm going to support your bill, but I want to see if you know the answer to this. So the last sentence talks about the enforcement and the penalties, and so if someone violates this, you can bring an action under the Consumer Protection Act. If Delegate Simon's class action bill passes and is signed into law, which provides for class actions for violations of the Consumer Protection Act, would then your practice that is prohibited fall under that, and people could aggregate those claims into a class action?
Delegate Ballard, you're a better lawyer than me. Mr. Chairman, I'm just pulling his leg. I don't know the answer to that.
All right. Delegate Ballard, you said?
I'm good, Mr. Chairman.
All right. Delegate Fagans.
Thank you, Chair. So for the patient, one of the biggest questions from looking at this is when you're looking at accepting cash, and I don't know if this conflicts with the current amendment that you had just submitted, but for a lot of the mobile businesses that we have right now, how are you going to take into account for many of them that don't always operate within the same place and don't normally carry cash, and the security risk that comes along with trying to keep cash on themselves, not having a physical safe and having to do a cash dump at the end of the day?
It's a totally reasonable question, right? And I don't, off the top of my head, have an answer for that particular hypothetical, but I'd be delighted to work going forward with you on how we can accommodate those businesses. If this thing doesn't pass this year, I just hope it passes one day.
Delegate Helmer.
Thank you, Mr. Chairman. Chair, question for the patron.
Delegate Helmer.
So, Mr. Chair, just so I understand, it's following up from Delegate Fagan's question. If businesses that don't really now hold large amounts of cash are going to be required to hold large amounts of cash, is that going to be a cost to them, and then they're going to be required to pass that on to the consumer?
Yeah, I don't think so. And I don't want to argue with you. I mean, you know what? There's a possibility you're right. But I think that gym owners said, hey, we don't, what are we going to do with all that cash? I doubt very seriously that we pass this bill and 10, 20, 30, 5% of gym customers start using cash instead of their cards. What it would do is allow people that don't have access to credit to go to that gym. What it would do is allow people that don't have access to banking to go to that gym. So we can sort of bicker over hypotheticals all day, but I just don't think in 2026 that it's going to become like, oh, we didn't have any cash and now we have lots of it. But respectfully, I don't know the answer to that, like no one does.
Mr. Chair, follow-up question.
Delegate Helmer.
Mr. Chair, so I just want to understand, though, currently my understanding is you're saying there are businesses that don't accept cash. Presumably those businesses are going to have to create infrastructure to, forget about the security or whatever, to accept cash. Means new cash registers, new places to hold them, new ways of doing business. And I just want to make sure you don't think that that's going to increase the cost to those, but we have to go study that. That's not going to increase the cost to those businesses. They're going to be passed on to the consumers.
Mr. Chairman?
Delegate Garrett.
Right. So my boss, my chief of staff says to me, you know how ridiculous it would have been to carry this bill 5 years ago because everybody took cash. So my experience has been that the businesses already have the infrastructure. The movie theater that I was at that said they wouldn't take cash had that sign hanging from a cash register. So I get your point. I appreciate the effort here, but I don't think, no, that it's going to be a great imposition on businesses to require the Regal Cinemas that already has a cash register to use it.
Delegate Helmer.
Speaking of the bill at the appropriate time, Mr. Chair.
Delegate Helmer, this is the appropriate time.
Mr. Chair, be all right if I make a motion first?
That would be great.
All right. Move to lay this bill on the table and speak into that motion, Mr. Chair.
Delegate Helmer.
Mr. Chair, someone who runs a small business that doesn't take cash because we're a service provider, and knowing many other small business people, including folks who don't have the infrastructure to take cash, this would be a massive cost to businesses across the Commonwealth of Virginia. This is going to increase costs for everybody here. All of us here on this side of the aisle have said we're dedicated to affordability, and so I hope that we will lay this bill on the table.
Second. So it's been moved and seconded to lay the bill on the table. It's not debatable. Let's go to the big board. All right, by a vote of 5-2, that bill is tabled. Thank you, Delegate Garrett.
Thank you, Mr. Chairman. Y'all have a great day.
All right, we have two bills before us, two remaining bills. One is Delegate Fagan's. Oh, we'll go at ease for a moment. Let's come back. So we are going to take Delegate Fagan's bill on prevailing wage by for the week, HB 569. It will be in our last subcommittee meeting next week, and so that leaves us with one more bill. Actually, hold on for one moment. Go at ease for one moment, please. Thank you. Let's return. All right, so we have one more bill. Once again, Delegate Fagan's bill on prevailing wage will go by for the week, HB 569. We have one more bill, and I do appreciate everyone's indulgence of the lengthy 20-bill docket we've had today. In the interest of time, I will present from right here. It's my legislation. Here we go. HB 925, and I will hand over the chair's gavel to Delegate Converse Fowler. May I proceed?
Yes, proceed, Delegate Lopez.
Thank you. So Virginians face employment discrimination, or facing employment discrimination, deserve to have a reasonable amount of time and ease of access to file complaints and take up civil action if needed. People are often unaware of their rights in the face of discriminatory practices, and can take weeks, months, or even years for them to learn that the way they were treated was in violation of the Virginia Human Rights Act. And often by that point, the window to file a complaint is already closed. The current 300-day limit is entirely arbitrary and doesn't align with the statute of limitations in much of Virginia's tort law or in other VHRA accommodation protections, which has caused significant confusion amongst the workers involved. The resources to take action on a VHRA complaint are quite limited as well. As it stands in the code today, if 180 days have passed since a complaint was filed, the aggrieved person may begin a timely civil action in the appropriate court. The trouble is, this exclusively applies to complaints filed with the Office of Civil Rights and the Attorney General's office. All of the alleged victims who file with more accessible local human rights commissions are not granted this privilege. Madam Chair, this bill would extend the Office of Civil Rights complaint period from 300 days to 2 years after an alleged discriminatory violation, giving victims more time to learn about their situation and prepare for the legal actions that may follow. This would also minimize confusion for workers, aligning it with other tort law and VHRA statutes. This would also match practices from other states, including Ohio, Michigan, Washington, Vermont, and New York, and other states as well. And then additionally, Madam Chair, this bill would allow any aggrieved person to file a civil action if they have not been informed of their rights to do so within 100 days of filing a complaint with a local human rights commission, rather than exclusively with the Office of Civil Rights or the Equal Employment Opportunity Commission. Finally, Madam Chair, this bill will make sure that Virginians suffering from discriminatory practices have sufficient time and access to use the laws that are meant to protect them. I hope it's the will of the committee to approve the bill and pass it, and pass it this evening.
Thank you. Do we have any questions from anyone on the committee? All right, all those in here to speak in support of the bill?
Madam Chair, Judy Conti on behalf of VLM-AWILA. For all of the reasons that Delegate Lopez stated, we are very supportive of this bill. Thank you.
Thank you. All right, we got another support.
David Berter with the SEIU Virginia State Council. We support this bill.
Thank you so much. All right, any of those in opposition to the bill? Go ahead.
Thank you, Madam Chair. Members Ethan Betterton, Virginia Chamber of Commerce. Do have some concerns with the bill, but appreciate the patron taking the time to work with us and look forward to continuing to do that. The bill moves forward. Thank you.
Thank you so much. Do we have anyone online? No. All right, we're back to the committee. Any questions or comments?
Move to report.
Second. All right, we have a motion to report, and clerk, can we open? Oh, did you want the last word, Delegate Lopez?
Oh, no.
All right, let's open the roll.
There they go.
All right, close the roll, and a vote of 5-2, that bill reports. Back to Delegate Chair Lopez.
Thank you, everyone, for sticking out with us for less than 3 hours, but we do appreciate it. And we will have one more subcommittee meeting next week before the crossover period. And so thank you very much for all of your work, and this committee shall rise.